The entire projection on the part of the petitioner is on the allegation of violation of the provisions of the Act of 1995. And in this connection, reliance has been placed upon the cases of students. So there is absolutely no dispute to the proposition that the provisions of the Act are mandatory in nature. However, it transpires from the facts and circumstances that there is serious dispute as to whether the petitioner had actually applied under the aforesaid quota. To resolve the dispute, the court has looked into the materials and the pleadings. There is no statement in the writ petition that the petitioner had applied under the said quota pursuant to the advertisement. Application of the petitioner has not also been annexed. What has been annexed is Annexure 5, which is a subsequent representation, wherein a mention has been made by the petitioner that of the aforesaid category. The connected pleadings is made in paragraph 7 of the writ petition, which has been verified in the accompanying affidavit as true as per information derived from the records. As regards the materials on record, the petitioner has annexed an identity card as Annexure 1, the date of the issue being 6/5/2005. There is a clear stipulation in the said identity card that it would be valid for 3 years. That apart, there is also a clarification that it was to be issued only to children below 18 years of age. However, the date of birth of the petitioner has been given as 1/3/1986, which means that she was above 18 years at the time and otherwise also not eligible for receipt of such identity card. Further, in the instructions appearing in the said card, it has been specified that the eligibility is only to claim concession benefits by the central government, state government, and other statutory bodies. Therefore, for all practical purposes, this identity card would not be of any consequence towards the claim of the petitioner. In the present case, the petitioner has also brought on record a unique disability ID, which has been annexed in the additional affidavit filed in the case by the petitioner on in January 2024. Said unique disability ID has been issued only on 9/3/2020, which is much after the advertisement of 2014, and therefore would be of no relevance as the same was not a matter of consideration at the time of decision-making process. The court has noticed the relevant pleadings in the said additional affidavit made in paragraph 9, which has also been verified as true to the information derived from records. Those statements made in a rejoinder affidavit can be treated as part of the pleadings and laid down by the Honorable Supreme Court in so and so. The said statement in the present case would be of no aid to the petitioner. Writ petition is accordingly dismissed.
May I borrow the
Yes.
Next, I beg to mention item number 10. Kindly be adjourned for 2 weeks. I have to file the affidavit.
Item 10 is of 2018. No adjournment. No adjournment.
I have it around 9, but I missed the file, Lordship. Little accommodation, Lordship.
Sorry.
With the consent of other side, the contempt petition, item number 47. A writ appeal is pending, Milord. But I request little bit more time, Milord. After 2 weeks, Milord. With the consent of other side.
You inform the other side.
Yes.
On the prayer of Sri P. J. Fukan, Learned Counsel, appearing for the respondent, the matter is adjourned by 2 weeks. 47, 2 weeks. Yes.
May I please? Look at the consent of other side, but I went try to fight
5 years.
for 2 weeks.
Sorry. 17 matter. Don't make mentions of matters prior to up to 18.
My please, your Lordship. My Lord, I beg to mention item number 33. Bail hearing matter.
Bail
I
hearing.
may be allowed to withdraw this petition.
You were not appearing earlier also.
Yes, ma'am. I am sorry, my Lord. If you
Sri J. H. Saikya, Learned Counsel, for the petitioner submits that he has instructions not to press this application filed under section 438 of the CRPC in connection with so-and-so, Miss so-and-so Begum Learned, additional PP is present. Para, the application is accordingly dismissed as not pressed.
Problem.
Yes.
may I please, your Lord. Lordship, I beg to mention item number 44, Lord.
Yes.
Lordship, here the order is compliant, Lordship. I may be allowed to withdraw that.
Sri, item 44, Sri H. Talukdar, Learned Counsel, for the petitioner submits that during the pendency of this petition, the order dated so-and-so, passed in WPC so-and-so, has been complied with. Dekh lijiye, huh? Para. In view of the aforesaid submission, the contempt petition is closed.
Obliged.
Yes,
I'd like
Mr.
to mention
Mazumdar.
item number 8,
My lord, item number 54. Hearing column, my lord, I need some instructions from the petitioner, my lord, could it be after a week, my lord? 19, my lord.
19
Uh,
matter.
My lord, it's a termination from service, my lord.
So what
Recently I've been engaged-
instruction?
My lord, I have been recently engaged, my lord, I need one or, because they have depended on medical certificates. Few documents I have sought from him regarding that medical part. my lord.
Sorry. Yes,
Like,
let the concept of others, I'd like to mention item number 8,
8.
any other day, madam.
We have asked you, we have already made it clear.
Sir.
These matters are not for adjournment, sorry, yes.
My senior is out of state.
Doesn't matter,
Provided.
doesn't matter, you have to do yourself.
Item number 19, Lordship. Then for
Item
the-
number?
Item number 1919,
Yes.
item 50, Lordship.
Again, an old matter, madam, why are you mentioning old matters?
And I did not be decided what he do, Lordship.
Today, my lord, there. Of part, that, it made a divorce.
It's gone.
Lord,
What is there to be decided? Let the matter reach, we'll close this. Don't mention old matters unless there is some exception and urgency.
The last step.
Sorry, let the matter reach.
Make it. Sir, item number 5, madam. I appear for the respondent number 6, madam.
Yes,
Sir, we have withdrawn from the matter, madam, that same has been notified to the client or
okay, we'll note.
to notice.
We'll note. We'll go ahead with the matter. We'll note your submission.
Thank you,
Item,
Your Lordship.
item number 5, no? 5 would go anywhere.
Respondent number
Withdraw.
6.
R6. Okay,
I beg to mention, Lordship, item number 4. The petitioner don't want to press the
what is your name?
RR cycle, Lordship. My name is
R Saikia.
RR.
You're for whom? I Rafiq.
I
Miss R Saikia, appear of an instruction of Sri I Rafiq, learned counsel for the petitioner, submits that there is instructions from the client not to press this petition, full stop. Sri Ardhar, learned state counsel is present. Para, writ petition is accordingly dismissed as not pressed.
Okay.
Yes,
May I please, Your Lordship? Lordship, I beg to mention item number 18. My
Yeah.
senior is outstation. Matter be adjourned for check.
18. Again, a 20 matter. Why are you mentioning 20 matter, madam? Who is your
Lordship, I'm
senior?
not in this case. My
Who is your
senior-
senior?
She's out of station.
Who
Lordship.
is your senior?
M. Bora.
Yes, who is for the other side? We'll have this on
Second.
Wednesday.
Yes.
We'll have this on Wednesday.
Hence,
A prayer for adjournment has been made on behalf of the petitioner. Full stop, para. List on Wednesday. 24. 24/4. Yes.
Item 1.
May I please, Your Lord, though are there directed to file our additional affidavit, if our previous stated, our then is getting first affidavit. No need to file another.
Okay.
Also find that. But last.
Okay, let us hear Mr.
My petitioner, my lord.
Karania, then we'll
Fine.
decide.
My lord, petitioner joined as the LD assistant, my lord, in the year 1986, my lord. In the office of the deputy commissioner, my lord, Dorong, my lord.
Just a minute, please. Joined as
LD assistant, my lord.
when?
At in the year 1986, my lord, 6686, my lord,
Where?
in the office of the deputy commissioner Dorong, my lord, Mongoldoy.
Okay.
Hereafter, my lord, I have been transferred to the Odalguri. That time you was a subdivision, my lord.
Correct.
Same post, my lord. Thereafter, my lord, the 2003 the my BT Act has come, my lord. The Odalguri became a district, my lord.
Hmm,
My lord, district of the PTC, my lord.
okay.
So, my lord, then, my lord, the respondent, my lord, Deputy Commissioner Odalguri, my lord, due to vacancy arises, my lord, they initiated promotion, my lord, 2009, my lord. So accordingly, my lord, they are supposed to be promote me, my lord, but ignoring me, my lord, private respondent is who are junior to me, my lord. Basically, private respondent number 8, my lord, Forester Brahman. He is junior to me, my lord. 7, my lord, not 8, 7. Now my men, my lord, is
Who has been promoted? R7.
R7, my lord. Rest are also promoted. They are also junior. My basically that R7 was promoted in the reserve quota earlier than rest of the others. So my claim is that I should have been promoted in place of Forester Brahma, being senior to him. Lordship may come to the gradation list. I'll show my lord that Grade D and DC Dorong has prepared a
You're
gradation.
still working as LDA.
Later on promoted, my lord. Now I retired also recently, my lord. Only the national promotion now I'm
Later on, you were promoted.
promoted.
When were you promoted?
2013, my lord. I was promoted in 2013, my lord.
When was R7 promoted?
Then other respondent has been promoted, my lord, in the year 2009, my lord. 14/12/2009, my lord. Respondent number 7, Forester Brahma,
2013, you also promoted.
my lord.
Now retired.
My lord.
Okay.
Immediately after promotion of the respondent number 7, I filed a request before the authority that I should have been promoted. Then they said that, my lord, because I am drawing my salary in different head, which is control of the BTC, my lord. The private respondent, which is drawing their salary in the head of the state. I mean, because though it is the amalgamated, my lord, office, my lord. So now in their said that because of drawing of the salary in,
But
That-
why did you file the petition after 5 years?
not immediately, my lord, because the 14. I
No,
filed in 14, my lord.
he was promoted in 2009.
That my lord, I am making a representation, my lord. Then when I was promoted, because during that period, I say my claim was that I should have been promoted with so and my lord.
You came to the court after 5 years.
That was right, my lord. Because when I was promoted, I
You
thought
first-
I'll be promoted with
You have
even
to first
responsibility effect.
overcome the hurdle of delay.
That my lord.
On merits, you might have a case because drawing the salary from which head perhaps will not be of much consequence.
My lord.
It is the seniority. And what is the criteria?
Criterion-
It is seniority.
Seniority, my lord. That Assam District Ministerial Service Rule will be applicable, my lord. As per this, my lord, according to seniority, my lord,
From LDA to UDA.
LD to UTA.
Okay.
And
And
only,
your transfer was not on your own request.
no, my lord, I was, prior to creation of BTC in
No,
India.
was it on your own request?
No, my lord, no, not on my request, because they are,
From Darang to Udalguri, you said 86 you were appointed at Darang and in the office of the Deputy Commissioner. And at that time, Udalguri was a subdivision. You were transferred to
Well,
Udalguri. That was not on your own request
no.
for exigency of, in
My-
the interest of public.
According to a district standard requirement, I have been transferred.
Okay, but how do you overcome 5 years?
That is, my lord, I am making a representation, my lord. Not to come to
Repre-
representation, my lord. It is not that I have
Represent-
not agitated the matter before the authority.
See, representation
And they have also,
submission will not extend or will not overcome the
they
negligence.
have also wrote to the Lower Assam Commissioner, my lord, to,
Where is
my-
the document?
my lord, not to come to my lord.
See, even if we are entering into the merits,
My lord.
then also perhaps we are not touching respond number 7. You have already retired. The
My lord,
only,
only for, my
only-
claim is for national promotion.
okay, if you are successful, we can direct, you may be entitled for a direction for fitment
Right.
of your pensionary benefit
lord.
as if you were appointed
In
in the
2000,
post in the year
promoted in
2009
2009.
itself. And monetary benefit, that will also not come, but fitment and national benefits, yes,
Minor.
that is the only consideration. Where is the document from the authorities?
my lord, the, Lord, you may come to my lord. The gradation list now, I am not coming, my lord. The order dated, my lord, annexure 3, my lord,
Page
page 29.
20. Yes.
This is, my lord, the 4th person has been promoted, the Horace Brahma is the last, my lord,
Page 20,
page 28,
28.
page 28.
28 is the order of promotion.
My lord, where the private respondent number name 7 is
Okay.
reflected in serial number 4.
Hmm.
Then, my lord, after that, my lord, I file a representation before the commissioner, my lord, for some division, my lord.
Category of reservation. But Horace Brahma is unreserved.
My lord, here they have shown unreserved, but he has been promoted on reserve because others, so many general candidates above him, my lord. So they have shown here, my lord. Actually, that time they have, my lord, informed that he has been promoted in a reservation, my ST reserve.
Where is the explanation?
My lord, Lord, may come to. My lord, that document I have not annexed, my lord. Anyway, my lord, otherwise I am senior to him, my lord. If it
No,
is,
if you are in a different category,
my lord. I am otherwise, I am also, my lord, reserve category, he also reserve
no,
category.
where is he is shown as unreserved.
My lord. Even then also I am senior to him, my lord.
No, if the roster point
Why not?
is meant for an unreserved, your seniority, will it matter?
Even then I am senior to him, my
No,
lord.
no. Your seniority, will it matter if the roster is for unreserved? This is not a recruitment, this is a promotion exercise.
But that is according to seniority, my lord. I am senior to him, my lord.
Suppose a general person who is senior in a gradation list is there and a roster is for an SC, will he get? Only because of the claim that I am senior.
That, my lord, is to some extent.
No, you have to show some materials that this respond number 7 is actually in your category.
My lord,
Since you belong to the STP,
my lord. Let's make come the my lord, executive, my lord, representation, my lord. Promotion order, my lord.
Yes. at page 28.
28, my lord.
Yes.
Whereas the government of Assam sanctioned 32 posts of vacant, newly created posts in the filing of the amalgamated establishment deputy commissioners, so extension of validity of the period of filling of the vacant post, sanctioned post of grade 3 and grade 4 by the government of Assam General Administration Department 5 memorandum. Whereas as per the direction of the Commissioner Lower Assam Division Guwahati by letter selection committee was constituted by the Deputy Commissioner Odalgiri by order dated where the selection committee considering the filling of the 4 nongs of vacant post newly created senior assistant post in amalgamated establishment of the Deputy Commissioner Odalgiri sanctioned by memorandum accordingly to gradation according to the gradation list by promotion. Whereas pursuant to the aforesaid approval, Deputy Commissioner Odalgiri in the interest of public hereby promoted the following assistant post of scale in the strength of matter. Thereafter, my lord, I will come, my lord, that why I am claiming that it is promoted as an ST, my lord. My representation I have submitted, but that has been, my lord, for a submission of representation regarding next page, my lord, 29, to the rank of senior assistant UDF from the junior assistant to the assistant deputy commissioner Odalgiri.
Page 20?
Next page, my lord, 29.
Yes, submission representation, okay.
This is my representation, my lord, immediately after promotion of the
This
respondent.
is the forwarding.
My lord, this is the forwarding. My representation has been forwarded. My lord.
29,
So my representation has been, my lord, in the next page, my lord. This is forwarding, my lord.
21, 1, 10. Forwarding or representation. So we don't. Okay. Your representation at 30. 30.
My lord, 30. I have reprinted on my lord 6/1, 2000.
No, it's 21-1,
21,
same date.
my lord. This will be forwarded, my lord. Again, my lord, deputy.
Let us read it. Let us have a cursory glance
My lord, my
with
lord.
your
My lord,
representation.
with reference to the merit, my lord.
Yes, please.
With reference to the subject cited above, I have the honor to inform you that as one of the victim, I lay before you the following few lines for favorable kind perusal. That sir, I have been appointed as LDA 5 DC Dorong Mongoldoy order dated so and
You
so.
come to the last paragraph. These
My-
are your prelude, last paragraph of this same page,
My lord.
paragraph 4.
That sir, Horeshwar Brahma,
Yes.
junior assistant who joined in the service 26,686 and junior to me,
Hmm.
but promoted to the next higher rank of senior assistant, 5 order dated so and so
Hmm.
enclosed here.
Yes.
That sir, suddenly the DC Odalbury has changed his view and took and decision promotely to promote them who are drawing their salary under the head of 2053 consumer. Because they have been promoted only because of they are drawing the salary 2053. That is head of the amalgamation department, but it's not under the control of PPTC. It's under the control of state government. That serve for the region earlier relation list of grade 3 staff of the amalgamated establishment of DC Odalguri Dorong
Hmm.
has been cancelled and prepared a fresh list excluding the names of the employees who are posted under the various amalgamated branch of deputy commissioner
Hmm.
enclosed here.
Hmm.
If so, them after creation of the BTC of Odalguri, how it was possible to make a various promotion order as mentioned below. So these are the other promotion order where they have followed the same norm. In case of us, they have, because of we are doing the salary in the different head, which is control of the BTC, we have been not considered for promotion method. That is my representation method.
Hmm.
Then my lord, again, my lord, deputy commissioner, next page,
Finally, you were promoted on 8/7/2013
my lord.
at page
But
38.
even that also not cancelled, my lord. It is in my. I have been
Okay, yes, what is your stand?
And 27/12/2013, I have been promoted later on.
Okay.
This worship is exercise transfer sub as separate and set from prepared get expert. It is not or under visit for
Now, this transfer is made by the DC office.
one is made by DC office and we have promoted him under our headquarters.
No,
We exercise we have
no, see, madam, at page 38 is Mr. Sarania's order. Page 38. That is also passed by the Deputy Commissioner Udalguri.
Yes, Lordship, because the DC office, though he was working in DC office, he was later on after bifurcation to PTC, he working under excise department. Since excise is the transfer subject, Lordship, we have prepared separate direction. And accordingly, he has promoted in the year 2013. We have stated our affidavit in ranking page Lordship 56.
No, madam, you are on a different tangent. You are not on that. We are not on the promotion order of the petitioner. Petitioner's order of promotion in 2013 is not relevant to the issue. Issue is relevant is the order of 2009
Yes.
when the respondent number 7 was promoted.
Yes,
Whether you have promoted the petitioner later in a transferred subject or not, that is not too much of a relevance. While making the promotion exercise of 2009, was the petitioner considered? Number one. If he was considered, then why the respondent number 7 was given the benefit of promotion? Number 2 and number 3, the order, prima facie shows promotional order of page 28 that respondent number 7 belongs to the unreserved category. If he is unreserved and there is no material still now to show that he comes within the same category of the petitioner, then perhaps we may not go into the merits also. But that is a clarification. He is he's reiterating that he and the respondent number 7 belong to the same category.
That same day he has stated lordship earlier.
Okay, Mr. Bora, you have
nowhere
already
stated
said.
lordship and
Yes, your lordship. Yes, right there. And lordship.
I think the decision will be more of this deputy commissioner office.
Yes.
No, your
Not-
lordship, what has happened as the postponed on 3/7/2013.
You come this side. Eight, seven,
8/7/2013, the
Yes.
deputy commissioner passed this order of promoting the petition. But
not the,
then
bit- not the, his promotion.
yes, and your lordship may note the head of account that is 2039XX
Promotion.
in the promotion order. It
No,
reflects.
eight, yes, that we have seen, no, we are not on 8/7.
Then your lordship may come to page number 41. Annex 9.
Just a minute. Page 41.
Page 41, Annex 9.
Yes, please.
Wherein the joint secretary PTC wrote to the deputy commissioner referencing this particular letter dated 8/7/2013, saying that this you cannot promote the petitioner because this is a transfer subject. Since all these pay and allowances to be paid by the PTC, so this particular promotion order is not paid.
Hmm.
And accordingly, we have filed the affidavit also. We have taken that particular stand. If you lordship peruses to our affidavit, more specifically, at paragraph number 4, it is filed by the DC.
Yeah, just a minute, please.
Yes.
113. Nine. This is. Oh, this is. Okay, your page, which page?
Page number 2, paragraph number 4,
Your affidavit.
filed by the respondent number 2, Dibakar Dole.
Yes, what have you
At
said?
paragraph number 4, we have stated that as regard to statement made in paragraph number 8 of the date petition, the deponent begs to state that the respondent number 7, Sri Forrester Brahmo, is an employee under head of account 2053 district administration, but the petitioner is an employee under the head of account 2039, which is transferred subject to PTC Kokrajhar. Next paragraph, your lordship, that is regards to the statements within paragraph number 9 of the date petition, the deponent begs to state that the promotion of Sri Forrester Brahmo, respondent number 7, was considered for promotion despite of the seniority of the applicant, since the applicant is an employee under head of account 2039, which is transferred subject to PTC. There again, your lordship, next page, paragraph number 9. We have stated that as regards to the statements within paragraph number 19 of the writ petition, the deponent states that the respondent number 7, Sri Horace Promo, is an employee under the head of account district administration, but the petitioner Sri Lenin Musahari is an employee under head of account 2053, which is transfer subject to PTC Kokrajhar, as such could not be considered for promotion despite of it. So that is the stand. His department is excise department. It was a transfer subject. That's why. Our promotion order, in fact, was it was objected to by the in terms of 1/8/2013. And
It was
thereafter, your lordship,
No, at page, paragraph 9. What-
There's a mistake also, my lord, regarding head. It should have been 39 in case of me. Same head, 2053.
Yes,
maybe it's a typographical mistake, your lordship, but we have stated so in paragraph number 4
okay.
and 5.
Mr. Sarani, where is your first order of appointment?
My lord, annexure 1, my lord. in
Page
Total good.
20,
Page 20, my lord, yes.
20. No, Mr. Bora, if you,
I can be accommodated any department, my lord. under
that's to examine your submissions which you have just made, first, your submission are not very relevant because you are concentrating on the subsequent order of the petition of 2013. We are not on that. Your entire claim is that while making the promotion in the year 2009, you considered the respondent number 7 as belonging to head of account 2053, whereas the petitioner was under head of account 2039. Now, to examine that, we have to fall back on page 20, Annexure 1. Annexure 1, this is the order of appointment as LDA. Is there any reference to that he is not under the deputy commissioner but under the excise department? There is no, his induction in the excise department or in the transfer subject came, had seen the light only in the year 2013.
Lordship, let me seek instruction as to how he came to be transferred to the excise
No,
department.
see, that is your prerogative, whether one person from a non-transfer subject is transferred to transfer subject, that's a different matter. But by that, number one, no prejudice can be caused to him, number one. And initial appointment seems to be under your establishment, deputy commissioner. There is no conditions attached at page 20. No rider, nothing that he is under excise or something. And this is a letter prior to the creation of BTAD.
And secondly, my lord, in page 44, where my learned friend read, my lord, last paragraph, they have said, this is amalgam, anybody can replace any department. They have their assertion, my lord.
No, see, they are on affidavit, they are stating that the head of account has been taken into consideration. Maybe they may be right in contending. They may be, we'll
Right.
still examine.
My lord.
But to make even to examine that submission, it has to be first established that initial from the inception,
I
your
was in
head of
excise.
account was under the excise,
And I excise.
which
2039,
does not appear.
my lord. Even, my lord, some of them, my lord, in ideal occasion, they've been changed the account only to promote. Prior to 2013.
Lordship, I have to actually, if your lordship gives me 1 day's time, your lordship,
Just a minute, please. The same head. Last one, head of account. See, these instructions will not be relevant at all. It is all post his promotion.
Post.
We are not on that. We are not post 2013. 2000, the excise department's role came only after 2013. Prior to that, he was an employee under your establishment of deputy commissioner. And this instruction is only on the consideration that he retired as an employee, excise employee. After his promotion as LDA, UDA, he was drawing account salaries under the excise account. So these are not relevant. But you have still not addressed on an issue which the court had raised. Number one, the delay. And number two, more important, delay also after so many years, we may not be very strict. Initially, we'd have, may not have entertained. Now, after 4 or 5 years, we may still entertain. But the other aspect is that respondent number 7 has been held to be UR, unreserved. And he claims that R7 is in the same category. If you stick to the what is appearing from the record that he was an unreserved, he was taken as an unreserved, and because the roster point is also mentioned, what is important? It's not that he was just promoted. You see the promotion order at page 28, the third column,
14,
page 28.
roster point is 14.
Roster point is 4. There are roster points.
Yeah.
So even from 1, 9, 10, 13, 14, that means the vacancy was earmarked. It was meant for an unreserved category, and where he may not have a claim. And there is no indication that you have de-reserved post.
First, I was coming to that delay portion of, so because the Your Lordship actually directed the question with regards to this particular issue, as to on what basis he was promoted. I would have actually started with the point of delay, because this particular order is of 2009. Even though he represented, then also he approached this honorable court quite late, because that would be unsettling a settled position. And basically, and also, of course, I have to seek instruction as to how he went to be transferred to the office of the
Mr. Bora, Mr. Bora, unfortunately, there is nothing in your affidavit opposition. You are developing this argument only because the court has put a question.
So,
There is
I
no
agree.
bar as such, but this is the
I-
basic point. You should take 5 years. What were you doing? Court of equity.
I-
You have not done, you have not said anything.
I-
There is not even a preliminary objection or even an observation that he has come late or maybe as an afterthought.
was filed on 2000.
Anyway, my continuous representation is there, my.
That may not be enough. But only aspect which may come into your favor so far as delay is concerned is this writ petition is of the year 2014. After 10 years on the ground of delay, perhaps will not non-suit you. We'll still consider on merits. Oh, we'll have it on Thursday. Mr. Bora, Thursday. Thursday, we have heard almost only little bit of clarification. Third, Sri M. Saranya, learned counsel for the petitioner.
My lord, my lord, Thursday, my lord.
Also heard Sri D. Bora, learned state counsel, as well as MS R. B. Bora, learned standing counsel, BTC. Full stop. After hearing at some length, comma, Sri Bora, the learned state counsel, 6, for a short accommodation to seek instructions with regard to the instructions in this matter. Full stop para. Considering that this matter is of the year 2014, comma, 2 days time is granted to enable obtaining of instructions. Para, list on Thursday.
My lord, maybe on 13, my lord. Because Thursday, my lord, I'll be out of court.
Oh, today, Thursday, when? 13th of what? May? Or 30, 30. No, then Friday?
Maybe 29, my lord.
Friday?
Friday, my lord, my voting day. my
Okay, okay,
lord.
okay. No, that will not. Adikiman hor. Oh, then 24th. 24th. No, you're not taking next week. 24th. We are not saying anything.
Day after tomorrow.
Day after tomorrow.
Yes,
Day after tomorrow.
yes.
My lord.
Thank you. I did.
Yes,
That's okay.
yes.
The person to an order. Dated 1/11/2015. Petitioner was allowed to sit in the concerned examination. And direction was made by the state of this court that the result would not be declared.
Published, okay.
And last occasion, my lord, the court directed the original copy of result. But last occasion, we have produced the documents, but it is not clear whether he was passed or not. And direction was made that whether he was passed or not. These are the documents. That
But where is the petitioner? Where is the petitioner? Who are the council?
Mr. Vishwakarma.
Which Vishwakarma? As Vishwakarma? Not as this, it is K Vishwakarma, somebody else. R Mazumdar is there.
But,
Now-
now, you will what is about So Vishwakarma. K. Vishwakarma.
Who is K Vishwakarma?
That,
Just a minute. None appears for the petitioner on call. Whereas Sri A.K. Datta, learned CGC, as well as Sri D. Day, learned Standing Council, NF Railway, are present, full stop. In the interest of justice, this is a matter of the year 2017, full stop para. In the interest of justice, let a further opportunity be granted to the petitioner. Full stop. List on day after tomorrow. It is, however, made clear that in case there is no representation on that day, this court will pass consequential orders. Yes,
Yeah, please, Lord. My lord, last petition, my lord, 5/2024. The PNRT has been directed to file their affidavit, my lord, as last time.
sometime.
not filed.
Further instructions are waited.
You keep on taking your instructions, we'll dispose of this matter. You take your instructions thereafter. Yes, what is the matter?
Lord, my lord, the petitioner, he is, my lord, under the category of persons with disability.
Okay,
And my lord, he is, my lord, under the category of blindness. And
Okay.
3 person has been, my lord, reserved for the post of for the category of persons with disability.
that way.
And 1 person for blind. And my lord, he is under the blind category.
No, there is a separate category for visually impaired.
Yes.
Is it not, it is not within 3%?
Yes, within 3%.
Yeah, within
And 1
3%.
person from my lord, yes.
3%. There is
under
no
3%.
further categorization. It is
Yes.
3%. Okay.
Cumulative.
Thereafter, what happened?
My lord,
What was the recruitment exercise for?
my lord, gradation list, my lord.
No, what was, tell us the facts. What has
That,
happened?
my lord, he, my lord, applied for the post of, my lord, higher post. He was serving as extension officer.
Tell us that. When did he join the service?
He was joined in the year 2014, my lord.
Service
2002, my lord. He was joined in the post 2002
as what?
as, my lord, fishery extension officer.
Okay. Then
Thereafter, my lord, without considering the reserve category, my lord, the candidate from, my lord, general category were promoted.
when was the promotion? When was the promotion exercise?
And other benefits also not considered.
When was the promotion exercise? Which year? Tell us something.
My lord, that was, promotion was, my lord,
I'll give you the facts.
joining.
No, no, let him, why should you say, take your seat. It is his case.
Yes, my,
Mr.
my
Council,
lord, yes, my,
is this
my
a room for
lord,
make a
2000
telephonic call?
2014, my,
What is this? What, sorry? Minimum decorum you do not maintain in the court. Is this some kind of market or what? Casually you're making a telephone call? If you want to make a call outside, go outside the court. This is audacious. Yes,
my lord, page 28, my lord.
wait.
These persons were promoted to my lord next. Assistant Development Commissioner. And
What is the next higher
Yes.
post?
Assistant Development Commissioner.
Assistant
Development Commissioner.
Development Commissioner, okay. And these at 31/12/2014, these 4 persons were promoted.
Yes, my
Same, they were earlier fishery extension officers.
extension of. That now, my lord, my instruction is that, my lord, there are 2 posts, my lord, vacant, my. And
Now, you are
But-
aggrieved by what?
my lord, my lord, I am applied for the post of Assistant Development Commissioner, my lord. Next higher post.
Assistant,
And that was not considered.
Assistant Development Commissioner.
Oh.
Now, what is your basis of, what are your grounds of
Basis-
challenge?
Basis of, my lord, I made an representation before the concerned authority to consider my promotion, my lord, that is at page 25.
Yes.
Page 25 is the, my lord, representation made by the petitioner, my lord,
Yes.
to consider his promotion as well as, my lord, other benefits which has to be provided under the persons with disability,
Okay.
and that was not considered.
And what is the basis of your claim? Simply filing a representation will not do.
Yes.
What is the basis of your claim that
It
you,
is, my lord, he is, my lord, incumbent, only the incumbent who is under the category of persons.
no, is the
And
third,
there is a provision, my lord. 3% has
is
to
the
be-
3% quota still vacant on the cadre
My
strength?
lord,
What is the cadre strength in the post of Assistant Development Commissioner? How many posts have been filled up by persons in the category of PWD?
no, not a single.
Where have
sir.
you stated?
My lord, my instruction, my
Where have
lord,
you stated?
my lord, it is the, tomorrow, my lord. I will clarify.
We did not give time to the government. Why should we give time to you?
Yes,
17
yes, fine.
matters.
My lord, in my synopsis, my lord,
Yes,
uh, line 9, my lord,
yes.
the respondent authorities promoted from time to time the extension officer fishery to assistant development commissioner without including any teachable income.
Hmm.
Despite making various communications to consider his promotion under blind category and directions of the Honorable Apex Court dated, this is the, my lord, judgment of the Apex Court.
In the pleadings, where is the statement?
The buildings, my lord,
Anything else?
my lord,
Where is the representation, page 25?
25.
Okay. Yes, Mr. Hendrik.
But the chapter strength was initially appointed in the year 2002 as an extension officer. Later on, my lord, during his entry, he was not suffering from any disability as such. It was subsequently, my lord, in the year 2004 that he was affected visually, and apparently in 2007, my lord, he had submitted a certificate. And but case if that observation is done, then 4% or 3% of character strength 4 is not possible, my lord. It has actually not been identified. I have instructions with me, my lord, for your kind consideration. The promotion post, my lord. Take reservation in a promotion post. The total cadre strength is 4, my lord.
4.
4, just 4.
Or in the assistant.
Assistant district commissioner. So he's seeking 3% of 4, and that is not feasible, my lord, at this point. For direct recruitment in that.
This assistant cadres, assistant district commissioner cadre strength, this is a post in which, under your department,
Under
PNRD.
not PNR, my lord. Extension of the fishery is
Then the next post, promoted post,
from the next higher promotion post is ADC.
Assistant
That
development
is in
under the office of the establishment of deputy commissioner. Now, this cadre strength of 4, your instruction is in pertaining to which office? Is it the entire cadre strength of the state?
No, my lord, this is the PNRD. This has, my lord, this promotion has been given to him under Rule 11 of the Assam Panchayat and Rural Development Officer Service 2013.
Okay. That, and
Under
that
PN.
has a cadre of
Four.
assistant development officer.
Yes.
The strength is 4.
Strength is,
Okay,
he's seeking reservation of 3% and cadre strength of
okay. Okay. This is your instructions?
Yes.
Okay. Heard. 3 S.A. Ahmed, Learned Counsel for the petitioner. First of also heard 3 P. Hendrick, Learned Standing Counsel, PNRD Department. Full stop. Para. The writ petition has been filed with the following prayer put kore dibe, huh? Para. The facts projected is that the petitioner was appointed as Fishery Extension Officer in the year 2002 in the Department of Panchayat and Rural Development. Full stop. The next promotional post is of Assistant Development Commissioner. Full stop. It is the contention of the petitioner that on 31/12/2014, 4 numbers of incumbents in the post of Fishery Extension Officer were promoted to the next higher post of Assistant Development Commissioner. Full stop. However, the petitioner was not promoted. Full stop. The entire case of the petitioner is that he comes within the category of the so-and-so act, wherein as per which, 3% reservation is to be given for all such posts. Where is the certificate
Certificate, my lord, at page,
in this connection,
my lord, 24.
24?
24 is the identity card, my lord, identity card. Twenty-four.
The petitioner has also annexed your PWD I card, unique ID,
Unique ID. That is, my lord, page 18.
18.
One. Original is 19.
Mr. Ahmed, this I card at page 19, original.
Yes.
See, date of issue 27/2/2004. No
Yes.
problem.
Yes.
Valid up to not written. Then you see only for children up to 18 years of age. Okay, কি করলো রাস্তা? Annexed an identity card in this regard at page, as annexure B, full stop, para. 3, Ahmed, the learned counsel for the petitioner, has submitted that he had filed representation on 1/10/2017 to consider his promotion, which however has not been done, and accordingly, the writ petition was filed in the year 2017. Full stop. Para. It is no, no. It is further submitted. No, it is further submitted that no, it is further no. Para. So the learned counsel for the petitioner submits that he belonging to the PWD category, comma, under the so and so act, comma, it is mandatory to fill up the aforesaid vacancy reserved. Full stop. In this connection, comma, the learned counsel has also referred to the order dated so and so, passed by the Honorable Supreme Court in so and so, page 9, paragraph 11, orange flag. Wherein, no, full stop, para. The learned counsel accordingly submits that an appropriate direction be issued for promoting the petitioner in the post of Assistant Development Commissioner under the PWD category. Full stop, para. Per contra, comma, Sri P. Hendik, the learned counsel for the department, has submitted that admittedly the petitioner had joined the services as Fishery Extension Officer in the year 2002, and the claim made under the category PWD emanates from a certificate of the year 2004. Full stop. That apart, he submits that the cadre strength in the post of Assistant District Commissioner is 4, wherein the 3% reservation would not be applicable. Full stop. The learned standing counsel has also placed on record the written instructions received on 17/4/2024 along with parawise comments and the relevant documents. Full stop. Para. The rival submissions have been duly considered and the materials placed before this court have been carefully examined. Full stop. There is no dispute in the bar regarding the mandatory nature and obligation to fill up vacancies by following the reservation in the so-and-so act. Full stop. The claim of the petitioner is based on a certificate which has been annexed as annexure B. page 18, page 19, full stop. The said certificate was issued in the year 2004, that is, i.e., after the petitioner had joined the services as fishery extension officer, full stop. However, comma, that would not come in the way for considering the case of the petitioner for promotion, for a claim involving, for a claim for promotion to the next higher post, full stop. However, comma, the certificate has also mentioned that it was only for children below 18 years of age, full stop. Para. Be that as it may, comma, without dilating further into the aspect of the validity of the certificate and proceeding with the assumption that the petitioner indeed belongs to the PWD category, comma, what is relevant is to consider whether the aforesaid act could be made applicable so far as the present post of Assistant Development Commissioner is concerned, full stop. Nowhere in the writ petition, comma, the petitioner has made any statement with regard to the cadre strength in the post of Assistant Development Commissioner, and therefore the basis to make such claim cannot be ascertained at all, full stop. Para. However, comma, the learned
Lord, I have stated in my paragraph 14 line.
1-4,
Yes, page
We-
10.
yes,
Note the petitioner begs to state that without considering the grievances of the petitioner and the further process for promotion may not be continued. The state government, without preparing the office memorandum and without making necessary arrangements.
this is
with
not what
respect
is,
of
this
preservation-
is not the relevant. Where is the
Lord,
statement regarding cadre
last-
strength?
Last line, my lord.
Yes.
The respondent authority in a very superstitious manner from time to time has been promoting the extension officer to assistant development commission without considering the.
Where is
reserved
the
category.
cadre strength?
Total card. Yes, yes.
We are asking about cadre strength. We have read this part, not the case. However, কি করবো? Learned standing council of the department has submitted that the total cadre strength in the post of Assistant Development Commissioner is 4,
Four.
full stop. Therefore, comma, the contention made on behalf of the department that reservation of 3% would not be permissible is a sustainable contention, full stop. Para. When the aforesaid act is not applicable, comma, even in absence of adequate pleadings, comma, this court is not in a position to grant any relief to the petitioner, full stop. Para. In view of the above, the writ petition is dismissed.
Both of my lord, only my prayer is, my lord, feasibility allowances, my.
That is a different
Yes,
aspect.
consider, my lord, at page 20.
Is it a
That's
prayer?
the-
Is it your
That
prayer?
is your government.
Is it your prayer?
Yes, my lord.
Where?
Prayer portion, my lord. Providing the allowances in favor of the petitioner.
Where?
Promotion as well as, my lord, page 12.
Hmm.
It is therefore prayed that your lordship would easily be pleased to admit this petition issued rule calling upon the respondent as to why it in the nature of Pitamas. Chargery shall not be issued, directing the
Okay,
respondent
full
authority to
stop.
consider one person.
The
in that
aspect,
category.
while the claim for reservation to the aforesaid post of Assistant Development Officer has been negated, comma, if there is a provision for provision, is there a provision
Right.
for
Yes.
affording disability allowance, comma, the petitioner or the authorities may consider the same in accordance with law, provided or accordance to law. So to facilitate the same, comma, the petitioner may file a representation within a period of 15 days from today. If he is entitled, give him that allowance.
Absolutely. Yes. Obliged.
বহি লাগিব। Yes,
We filed our affidavit. The TP Bora is on late lordship in court number 1 lordship, TP Bora.
doesn't matter, let us,
No lordship, he is appearing in this case and he
let him come, we'll start off with Mr. Rahman.
will take some time there.
Doesn't matter,
Well,
we are not adjourning matters of this 2017, you start.
After some time.
Let him start, madam, we do
What?
not know how long will it take.
may I pay, my lord?
Yes,
My lord, that's not for target to it.
we have rejected. You place your case, otherwise we'll take it up
In
on our
this
own.
case, my lord, in this case, my lord, the petitioner applied for compensation government. But in 2016, my lord,
Nukala. Told us it. Yes,
petitioner applied for compensation government, my lord,
who had died?
father, my lord,
Father, when? Died when?
on 2022, my lord.
2002.
Two.
You'd filed this petition when?
2017,
17.
my lord. But there is communication, my lord.
7271. 2002. 30/11. 2002. Father was working as what?
Surveillance worker, a health department.
Okay, then
My lord, on annexer page 27, my lord, annexer D, my lord.
petitioner applied.
Details list of candidates on commission,
Page
page 27, my lord.
27.
Type copy, my lord. There is serial 14, my lord. The name of the petitioner reflected. Type copy, my lord.
This is prepared by whom? Which date?
My lord,
Date?
date, my lord, 13/8/2007, my lord. 28, page 28. Last,
28.
page 28, my lord. Original copy. Last person, date, joint director of health.
This is, what is the date?
13/8/2007, by the
2007.
right portion to the last person. That's the
It's
name
not
of the
2000, it is not 2007, it is 2004. If we have to correct your petition, what will happen now?
04.
You come to the forwarding at page 26. Petitioner, okay, name forwarded. By whom? Joint director.
in this case, in the forwarding, my lord, the name of the petitioner as serial number 14.
Yes,
Jitendra Das.
name forwarded.
Uh,
Yes, by joint director.
Joint director. But
the name of the respondent number 6 who has been appointed against my post, my lord, his name is not there. My lord. Actually, what happened, my lord? Actually, the name of the petitioner and then the name of the respondent is same, my lord. And he has been appointed against my post. My lord. This is my case.
Was respondent number 6 otherwise eligible to be considered for compassionate appointment?
His mother died, my lord, but he has been working in, and her mother was working as auxiliary nurse, midwife, my lord, and the petitioner father was working as a surveillance worker in malaria department, my lord. So, my lord, he has a right to appoint the petitioner in malaria, my lord. But where is my respondent?
No, is your case like this, that there was a mistake in identity and
Yes, not.
but you have not, it's not your case that the respondent number 6 had also applied for appointment on compassionate ground, and in fact you have admitted that his mother was also a government employee who had passed away. What is your claim? When did you come to the court first time? 2017?
Lordship, in 2016, my lord, in the month of June 2016, one person who is working as surveillance worker under the director of the came to the informed to the petitioner that the respondent was appointed as surveillance worker on compassion ground against his father who died in.
There's nothing to be decided here. Okay. Heard. S. Rahman, learned counsel for the petitioner. Also heard. Whose name? We record your name or DP Bora's name? MS D. Bora. Learned standing counsel. Health and Family Welfare Department. Para. The claim is with regard to appointment on compassionate ground. Para. The facts projected is that the father of the petitioner, Girish Chandra Das, was working as a surveillance worker under the Joint Director of Health Service, Dhubri, who had died in harness on 30/11/2002. Full stop. The petitioner accordingly had submitted an application on 30/12/2002 for appointment on compassionate ground. Full stop. The name of the petitioner was accordingly forwarded by the Joint Director of Health Services within bracket malaria on Joint Director of Health Services, wide communication dated 13/8/2004. Full stop. However, comma, the petitioner was not appointed. Full stop. On the other hand, comma, the respondent number 6 was appointed. Full stop. Para. Sri Raman, the learned counsel for the petitioner, has submitted that the petitioner had fulfilled all the requirements for such consideration, and therefore the appointment ought to have been offered to the petitioner. Full stop. It is also submitted that the respondent number 6 bears the same name of the petitioner, and instead of the petitioner, comma, the said respondent has been appointed. Full stop. The learned counsel accordingly submits that appropriate directions be issued to consider and appoint the petitioner on compassionate ground, full stop, para. Per contra, comma, Ms. Bora, the learned standing council has submitted that on the account of delay itself, comma, the petitioner is not entitled for any consideration, full stop, full stop, full stop. Even on merits, comma, no, she contends that even on merits, comma, no case for interference is made out as the consideration and subsequent appointment of the respondent number 6 was on merits, full stop. She also points out that the name of the petitioner, names of the petitioner and the respondent number 6 are entirely, are clearly distinguishable. Full stop. Whereas the petitioner is Jitendra Chandra Das, Z to Z likhiছে, whereas the respondent number 6 is Jitendra Biswas. Full stop. Para. On a specific query made by this court, comma, the learned counsel for the petitioner has, however, conceded that the respondent number 6 was also a contender for appointment on compassionate ground due to the death of his mother, who was a government servant. Full stop. At the same, he, however, clarifies that the mother of the respondent number 6 was not in the surveillance department,
No, madam.
was
ANM.
was an
Auxiliary nurse.
was an
midwife.
auxiliary nurse cum
Midwife.
midwife, and therefore the appointment could not have been offered to the respondent number 6. Full stop. Para. The rival contentions have been duly considered. Full stop. The law on compassionate appointment is well settled. Full stop. The such appointment is an exception to the general mode / method of recruitment, wherein an exception is carved out to give immediate succor to a bereaved family which has lost the sole breadwinner who was a government servant. Full stop. The essence of such appointment is of immediate nature, and the said essence would be lost by efflux of time. Full stop. Para. In the instant case, comma, the death of the father of the petitioner was in the year 2002, and the writ petition itself has been filed after 15 years. Full stop. There is no acceptable or cogent reasons explaining the delay, and mere submission of representation would not extend the time. Full stop. As on today, comma, more than 2 decades have passed, and any direction towards consideration of the claim of the petitioner further would not be in sync with the scheme of compassionate appointment. Full stop. Para. The Honorable Supreme Court, in the recent case of so-and-so, has laid down as follows. What was the name? Name? Devabrata Acharji. Tiwari. Laid down as follows. Full stop. Para. In view of the aforesaid discussions and the law laid down by the Honorable Supreme Court, comma, There is no case for interference is made out and accordingly, the writ petition is dismissed.
All right, Lord.
Yes, next. Oh. Kuntu? Etu next to. Kuntu, etu case আপনি? Oh, নালাগে। এটা লিখি দিব লাগিব। আৰম্ভণিৰে so and so. So আৰম্ভণিতে সুধিছো, Sri P. Mahanta, Learned Counsel, however, informs this court that though he was engaged by the respondent number 6, comma, he has withdrawn the wakalatnama. Yes.
The petitioner is seeking appointment on the compassionate ground. And his case was considered by the Security Committee. Lordship will find the comments for rejection at page 24. His father died in 2010. I applied in 2007. And this is in November 2016, the DLST meeting time. The rejection is that there is no vacancy against the
When did he, when was the death of the father?
2010.
Date?
1911, 2010. It's 1911, 2010. And I applied on 7th of January 2010
Father was working as what?
as junior assistant to the land reform department, the establishment of the deputy commissioner, amalgamated Dorong and Hong.
Okay. When did you apply?
But I applied on 7th of January 2011. About 2 months after my father.
Okay.
And my mother had expired earlier. But my father survived by myself and my younger brother. Now, my case was considered the DLSC meeting, which starts at page 20.
Date?
This is dated 11th of November 2016. The Lordship will find the relevant portion at under serial number 24, page 24. Serial number 24, Sabir Ahmed. The proposal is rejected as there is no vacancy against the compassionate post. Moreover, due to pendency of WTC 7318 of 2013, Sri Divyajyoti Dekka versus State of Assam and others in the Honorable Guwahati High Court, the process for recruitment of junior assistants has not yet started.
Yes.
Now that was observed that the process has not yet started. There's perhaps a stay order. And
What
this-
was the date of this meeting?
this is 11th of November 2016. At the very next page, what the process. 11th of November.
This is not the date of the meeting, mister. You should know the date of the meeting. It is
Uh,
110, 110,
110.
110,
110.
110. This is
Sorry.
the communication. We are on the date of the meeting. 110, okay. Rejected.
Rejected, saying there's no vacancy under compassionate ground. However, they say that there's the process is stayed by some order of the Guwahati High Court.
That we have noted, yes.
Now, immediately after, my lord, after almost 11 months, just the expiry of 11 months, the same establishment comes up with an advertisement for juniors. That is at page 26.
Yes.
Now, this clarifies that there is vacancy at that's why I approached this honorable court. This honorable court on
13th of September 2023 directs me to bring on record the orders passed with that particular restriction and also directs the state government council to get the instruction over the position of the vacancy of that particular year of competition. That has not yet been filed by my learned friend. However, I have filed an additional affidavit bringing on record the orders passed that particular writ petition. And the final order your lordship will find at page 39, annexure L. That affidavit. There, the matter was dismissed for non-prosecution on 6th of April 2018. There was a stay operating. I have annexed the stay order also.
Okay.
There was a stay operating over the recruitment of juniors. And on 6th of April 2018, it was dismissed for non-prosecution and the stay was also vacated. So after that, in the month of October 2018, they published the advertisement for the juniors. So clearly there-
Advertisement is of 2/6,
sorry,
page 26,
page 26 advertisement is of
2/6.
no, my lord. The last page, page 28. That is as per government letter. They say about the government letter, but the advertisement is of 9th of October 2007.
Is it 9th of October? Okay. Okay. 9th of October. Nine, 10.
Yes.
9, 10, 17.
Yes.
Okay.
Now that writ petition has also come to an end, has dismissed, and clearly there are vacancies. You know, they have published this advertisement,
14
So-
years.
my lord,
14 years.
but my lord, there was no delay on my part.
Manibrata,
My lord, I approached immediately
Tiwari.
after I was briefed by the minutes, and also after of this advertisement. And they have,
We are bound, Mr. Bharadwaj, with the judgment.
they have also not reverted back as of date, as per the
My
order.
lord, I will clarify that also, what my friend is arguing. That part also I will clarify. And
Manibrata has made, tied our hands. Even if it's a delay on the part of the
Yes, my lord.
authorities, even that has been covered. It, at times it's slightly difficult. You may not be at fault. If they are at fault and somebody may in fact, in a malified way, keep your application pending and say that time has elapsed. But unfortunately or whatever.
that is there, my lord, covered. And one thing just I want to clarify, my lord. If we go by page 26, my lord, number of vacancies 12. So, my lord, this 12 is for direct appointment, and when we have 20 posts, my lord, then from 20 only we can carve out one post for compassion appointment. That is 5%. So that is why we said, my lord, we do not have vacancy for compassion appointment. When until and unless we have 20 vacant posts, my lord, we cannot carve out.
There was a rider given to my rejection. They say that moreover, due to pendency of writ petition,
My lord, that is just a rider, my lord, but his thing is rejected on the ground that there is no vacancy. Vacancy was counted on the strength of the 12 posts, my lord. And 12 posts is, my lord, we cannot carve out one from that. 5%.
Okay.
And his thing was considered, my lord, in 2016. And 7.5 of Devarbrata Tiwari will, my lord, squarely cover this.
Heard. Sri P. Bharadwaj, Learned Counsel for the petitioner. Also heard Sri Ardhar, the Learned State Counsel for the respondents. Full stop. Para. The claim is towards an appointment on compassionate ground. Full stop. Para. The facts projected in the petition is that the father of the petitioner, Altaf Hussain, who was working as a junior assistant in the amalgamated establishment of the office of the Deputy Commissioner, Darang, had died in harness on 19/11/2010. Full stop. The petitioner, who claims to be qualified, had accordingly applied for appointment on compassionate ground on 7/1/2011. Full stop. However, the district level committee in its meeting held on 1/10/2016 had rejected the case of the petitioner, basically on two grounds. Full stop. Firstly, it has been reflected that there were no vacancies. And secondly, there was a stay on such consideration passed due to an order passed by this court. Full stop. Para. Sri Bharadwaj, the Learned Counsel for the petitioner, has submitted that the grounds of rejection, though may be relevant at that point of time, is no longer existing. Full stop. In this regard, by drawing the attention of this court to the annexures in the additional affidavit filed on 27/9/2023, the Learned Counsel has submitted that the interim stay order pursuant to which the selection was kept on abeyance was vacated by this court on 6/4/2018, passed in the concerned WPC 7318 of 2013, by which the writ petition itself was dismissed. Full stop. The Learned Counsel has also referred to an advertisement dated 9/10/2017, whereby applications were invited for appointment to the post of junior assistant in the said establishment. Full stop. The Learned Counsel accordingly submits that when vacancies were available and there was no impediment in the form of any stay order, a direction may be issued for consideration of the case of the petitioner. Full stop. Para. Sri Dhar, the Learned State Counsel, has, however, opposed the writ petition. Full stop. At the outset, the Learned State Counsel has submitted that the death was in the year 2010, and after an efflux of about 14 years, there any direction for consideration would not be in consonance with the scheme for compassionate appointment. Full stop. Para. On the facts of the case, comma, the learned counsel has submitted that though the impediment in the form of stay order was removed wide order dated 6/4/2018, comma, the advertisement which has been issued on 9/10/2017 would show that the would show that 12 numbers of posts were vacant, were advertised. Full stop. It is submitted that since the reservation is 5%, comma, no post otherwise also can be given to any persons under the aforesaid category. Full stop. Para. Last story. No, para no. The learned state council has also placed reliance on the recent judgment of the Honorable Supreme Court in the case of Bani Brata Tiwari, State Debabrata versus State of West Bengal. State of West Bengal. So and so. Para. Last story can hear it. এইমাত্ৰ মই হেৰিক দিছোঁ বিপ্লৱক দিছোঁ খালি তাতে 24 years আছিল এইটো 14 years হ'ব ওকে ওকে dismissed.
Play.
Item 7. Yes.
The matter relates to non-payment of salaries. Now, they were appointed, my lord, Anganwadi workers and helpers, my. As per advice.
How many of you are there? How many of you are there?
6, my.
Six
Right.
petitioners. 3, 6, 6. 6 petitioners. What happened?
If they were advisement was issued 5/9/2009, my lord, that's the.
5/9/2009.
9, my.
Page?
Right.
Page.
Page lost to 24 and 25.
Okay. Advertisement for Anganwadi worker and helper.
Helper.
Yes. What
They
happened?
were appointed, my lord.
You were selected in
Selected
appointment.
and appointed.
Okay. Okay. এটা নাম অলপ পিছত আহিব এটা নাম Yes.
On 13 August 2010, my.
13
August 2010,
13/8
my.
2010.
Page 29 to 34. Appointment.
Okay.
Thereafter, they filed a writ petition with the Honorable High Court, my lord,
Why?
for release of their salary.
Earlier also.
It's 2 times, my. It's third time, my.
What were the writ petitions?
Order date,
No, writ petitions number,
1987/2012, my.
order,
Order date was to page 38, my.
date,
Page 38, my.
date,
25/5/2012.
hmm. Okay. Page 38.
My. The given portion is page 39, my.
Hmm. Yes. Yes,
Next
this,
page, my lord, page 40, my lord.
this to dispose of representation.
Yes, my lord. The speaking order was passed by the department, my lord.
Page
40, my lord,
40.
in our favor, my lord.
Twenty-four, 7.
My, 12.
Speaking order, okay.
There was a 43, my lord, page 43.
What was what was this order?
Order was lordship.
By the district welfare, social welfare
Yes,
officer?
yes, my lord.
Hmm. What this due to certain could not be present. Okay. Hmm. Hmm. Thereafter,
Thereafter, lordship, page 43, my lord.
4-3.
43, my lord. The direct district welfare, issued another letter, my lord. There, they directed the treasury officer to release their honorarium or salary.
After the said order.
Yes, my lord.
No, this is almost the same. This is again by the district social welfare officer, isn't it?
Again,
District.
same authority, my lord.
Hmm. Yes,
Ultimately, they did not release, my lord.
not released.
Now, then they filed another petition, my lord. Lordship finally says page 46, my lord.
You are not being paid your honorarium since your appointment,
Yes, my lord.
from the very date of appointment.
From the date of. Then another order passed by the honorable court, my lord, page 46, my lord.
46.
Yes, my lord. Order dated 31st May 5, 2013, my lord.
Same petitioners.
Same petition.
2242. Yes.
Then, my lord, petitioner communicate this order, page 47, my lord, to the Directorate of Department of Social Welfare, my lord. Page 47, my lord.
Is
47, my lord, the power communication, my lord.
yes.
Then, my lord, being agreed by the Director of Social Welfare Department, my lord, pass an order, lordship, impugn order, my lord, page 48, my lord.
8.
And lordship, the given person is lordship 49, my lord.
Forty eight is 22nd May.
My lord.
Who has passed this director?
Director, my lord.
Where is the direction? 46.
Second last para, ma'am.
Yes, please read. Yes,
After
okay,
necessary order.
okay. Yes, so what
Direct-
order? Now what order has been passed?
Lordship kindly see the given person, my lord. Second paragraph, my lord.
Hmm.
In view of the above, it has been observed that the
mistake was committed by the in charge
Yeah.
CDPO of Askandi ICTS project and who had engaged
Paragraph. Page
page 49 miles.
49.
Mile.
Okay.
Second paragraph. Mile.
Yes.
In view of the above, it has been observed that the mistake was committed by the then IC CDPO Paskandi ICTS project who had engaged both the Anganwadi workers and Anganwadi helpers in those 3 minutes and Anganwadi workers without proper verification of the government communication. Therefore, the proposal submitted by the Director of Social Welfare Kachar by data dated 13/7/12 cannot be accepted. CDPO since we directed to terminate the persons who are engaged so and so Anganwadi center ICTS project under the Kachar as Anganwadi workers and helpers with immediate effect and take necessary steps for engagement of the so and so many Anganwadi as mentioned above. The above in view of the above disciplinary proceeding against the then Social Welfare Kachar for furnishing the false information in order dated 24/7/12 against the then child project officer Paskandi misinterpretation of the communication data so also honorable court so complied with objection.
Okay. Is any order of termination passed?
Yes.
Passed when?
No, nothing passed. First honorable passed the stay order. Order dated 29/11/27, my lord. Kept in abeyance the order, my lord.
29?
29/11/2017.
Let us see. Have a look. 29. Okay. Okay.
My now they actually Lordship, the advice when the advisement was issued, my lord, in 2009, they specifically Lordship kindly see page 24, my lord. Then there was specifically mentioned, my lord, is the Anganwadi center, both the worker and helper. Accordingly, they were interview, my lord, got selected and got the appointment. And thereafter, their salary was stopped, my lord. Subsequently, Lordship, from this very
No,
or-
no. Once you say salaries were stopped, that means for certain period you were paid the salaries.
no, my
From the inception, you have not.
not because they are confused on my lord whether they were appointed against the mini Anganwadi center or full Anganwadi center. If they were appointed, my lord, against the mini Anganwadi center, then there is one Anganwadi worker. And if there is full Anganwadi center, there is both will be valid.
You were appointed where? In full or mini?
Full, my
Okay.
Lordship, there are Lordship.
Also kindly see page 20, my
20.
20, my annexure 1, my.
Hmm.
For the many Anganwadi centers, my lord, the procedure, my lord, they stated. For in pursuance of the Ministry of Women Child Development Government of India, sanction 14/11/2008, I am directed to convey the sanction of the Governor of Assam acceptance 501 number of supervisor, also voluntary services, 12,524 Anganwadi workers and 12,524 Anganwadi helpers.
That we have seen, the second part,
Yes.
one angle,
And there will
center will have one AWW and one AWH for mini, there will be one W.
One, my.
Yes.
And last paragraph, my lord, this issue with the occurrence of the finance department.
That is okay, that is okay, that is not the part of the.
Now, see, there is a confusion, my. Government sometimes they say that due to their mistake, sometimes they are corrected different communication for correction of their mistake, my lord. And sometimes they are only minimum.
There are 6 numbers of petitioners.
Yes,
They are involved with 3 numbers of centers.
3 numbers, sir.
What are the names of the centers?
Center Lordship. The Lordship, there is, I have, their appointment mentioned in Lordship. Kindly see Lordship at page 40, my.
40.
40.
Yes.
Last bottom of this page, my lords, 8 number line, my lord.
Hmm.
Engage 44 number of additional Anganwadi workers and Anganwadi helpers after observing all formalities as per guidelines. Following 6 number of Anganwadi workers and Anganwadi helpers were engaged along with 41 numbers Anganwadi workers and helpers. Farida Begum so and so, dated so and so, my lord, Samsunesa so and so, Mojida Begum, and the respectively, my lord. Next para, my lord. Appointed and just below, my lord, second paragraph, next page 41, my lord. It is stated by the respective circle supervisor that said 6 number of Anganwadi workers and Anganwadi helpers are actually working 107 number Laskarani Anganwadi center, 111 number of Aadhar Gram Koraikandi Anganwadi center, and 114 Kunjui Basti Mamang Likai Anganwadi centers in the Pakandi ICTS project in the district of Kachar is a monthly fixed honorary.
Okay. These are proper Anganwadi centers, not mini centers.
No,
Okay.
my humble prayer, my first prayer may be considered. So they are at 9.
Are you still continuing?
Yes, ma'am.
That part I
We
have.
will come to it. That's all?
Right.
Yes.
That is okay. That part I have take instruction. First, there was a direction in page 49 in the speaking order, my lord.
Hmm. 29,
49, my lord, page number 49.
49.
Yes, my lord. second last para, my lord, the CDPO Baskandi ICDS project, my lord. My lord.
Hmm.
Page number 49.
Yes.
Second last, the CDPO Baskandi ICDS project is directed to terminate the persons who were engaged in 107, 1111 and 114. The concerned, my lord, is Anganwadi centers, my lord, under Baskandi ICDS project, under Kasaranga and helpers with immediate effect. So, my lord, once this order is passed, my lord, speaking order, I do not think that they were not terminated. That part I have to seek instruction, my lord, and take necessary steps for engagement of Anganwadi center as mentioned above. Further, there was, my lord, a direction to take necessary steps for engagement in mini Anganwadi center. That is there. So whether they are still working, my lord,
No, see, that aspect we may not go into.
Right.
Because 22/5/2017, this order,
Right.
there is an order, stay order of 29/11/2017.
Just continued, my lord, till now.
Have a seat, by which the entire order was stayed. So if the order was stayed, we have to assume that they are in service. But that will not give any indefeasible right to them to continue. We are adjudicating the matter finally.
Fine.
If you can show any grounds that their induction in the service was not in accordance with law, or there was some foul play by the district social welfare, which appears from this order. In fact, you have gone to the extent of initiating disciplinary proceeding against that order. Now, the aspect of whether they have any right to continue, that is one aspect. And the other aspect is the salary aspect for the period where they have rendered service. For the second aspect, you may not have much of a say, because if they are working, they have to be paid. But on this first aspect, whether they can continue on the basis of an appointment which is not in accordance with law, that you may have some, and we will still consider.
Fine.
Because that issue of the legality of the appointment was not ever raised. In fact, that is not even the
Yes.
issue till now.
Yes, my lord. They are on only the salary part.
Salary, but let us
Honorarium.
honorarium. Let us see what is your prayer, Mr. Oscar. But at the same time, if you want to terminate their services, aren't they entitled to some kind of a notice? We may not say anything regarding a full-fledged DP, because they may not be a very regularly appointed persons, but at least a notice, minimum hearing.
My lord, I do not know after this speaking order was passed, what step they have taken.
No, there is an order of the court, stay order of
Yeah.
November.
So maybe, my lord,
No, we can do one thing. See, you have come to a categorical finding
finding, my lord,
at
that
the highest
there
level
was-
of the director, that
Yes.
there was some
foul play, my lord,
some
foul play,
difficulty,
my lord.
some impropriety at the time of induction into the service. You inquire into that, give them an opportunity. If you
We
want
heard.
to have
Yes,
action,
yes, my lord.
I think
We
that will
discussed.
serve the ends of justice. But for the period they have worked, you have to release the salaries.
Right.
And why so? Normally, we would have still looked into the issue. There are two orders of this court on earlier occasions. The issue of their legality, illegality had never cropped up. And in both the proceedings, the director was a party. We are not saying that later on he cannot take the stand. He have taken the stand, but he should have taken the stand at the first instance.
My lord, thank you for a moment. my
We will
lord.
come to you, I have not decided.
So, yes, my lord, even to that extent, my lord, I will consider.
You give them an opportunity if you
Okay,
find,
my lord.
give them let
Yes.
them show cause. Within a particular time, you complete the formalities. Okay, what do you say?
My lord, when we filed contempt petition, my lord, then director Lordship filed an affidavit, and it's page 51, my lord. Second last, my lord, close to my 50 page viewer. Director replied, the file containing the case record was misplaced and found in the year 2017, my. Order was submitted in the year 2012, my lord. And director received found due to misplaced in the year 2017, my lord, after 5 years later.
None aware. Is the Anganwadi worker center running?
That up to my lord, we haven't filed any.
These 3 Anganwadi centers are running. Are those in operation?
Then today, my lord, all of them is running, my.
No.
Yes.
These 3 Anganwadi centers, are those in operation?
Recently, I'm not about the position.
Are you working?
Present position, I am not aware, my. Because they are not getting started 2009, my. Now 17, my. 2024, my.
You must be working somewhere else.
My.
Are you working somewhere else?
Yes, my.
You're working somewhere else.
They were working, my.
Are you working presently somewhere else?
I am not aware. Present position, I am not aware. Since after there are 2-3 years break, my lord, to coronavirus, my report was closed, my.
No, he's fairly submitted. He is not even asserting that, but we cannot ignore the court's order and the proceedings. We direct you, give you liberty, hold in minimum fact-finding inquiry, give them an opportunity, and you take steps. You can take the decision to discontinue their services, but that has to be done by following the due process number 1. And for the period where they have rendered service, you have to pay their salaries. We'll close this. Heard.
Not exactly DP, my lord, but.
No,
we'll
not
ha-
DP, not DP. We have said. Heard Sri J.U.N.M. Laskar, Learned Counsel for the petitioners. Full stop. Also heard Sri R. Dhor, Learned State Counsel, representing all the respondents. I have your set, please. Para. The present case has a checkered history, including a number of previous litigations. Full stop. Para. The facts projected is that pursuant to a recruitment process in the year 2009, the petitioners, who were 6 in numbers, were selected and appointed on 13/8/2010
My.
in the following Anganwadi centers. Page 41, tinta ase, Page 41, 107 eta ase, 111 eta ase, 114 naam bilak pura di dibo. Full stop. The appointments of the petitioners in the respective centers were as Anganwadi worker within bracket AWW and Anganwadi helper within bracket AWH. Full stop. Since salaries, since the honorarium of the petitioners were not paid, they had first approached this court by filing WPC 1987 of 2012. Full stop. The said writ petition was disposed of wide an order dated 25/5/2012 directing disposal of the representation filed by the petitioners. Full stop. Para. Subsequent, no, para nahi kale. Subsequent thereto, comma, a speaking order was passed by the district social welfare officer, comma, Kachar, whereby the claims of the claim of the petitioners were accepted and steps were said to be taken for release of the honorarium. Full stop. The aforesaid speaking order was followed by a communication dated 31/7/2012 to the Director of Social Welfare for release of the honorarium. Full stop. Para. As no action was taken, comma, the petitioners had filed the second writ petition WPC 2242 of 2013, which was disposed of wide an order dated 31/5/2013. Full stop. This court had directed the authorities to take necessary steps for release of the honorarium. Full stop. The Director, comma, Social Welfare, however, wide the impugned order dated 22/5/2017 had directed for termination of the appointment pertaining to the aforesaid three Anganwadi centers, and also to take necessary action against the concerned district social welfare officer, comma, Kachar, for misleading and giving wrong information. Full stop. Para. Sri Laskar, the learned counsel for the petitioners has submitted that the aforesaid impugned order is not sustainable in law, in as much as the petitioners were not given any opportunity. Full stop. It is further submitted that the induction of the petitioners in their respective services were done by following the due process of law. Full stop. It is also submitted that the vacancies being properly notified and the petitioners being appointed in a full-fledged in full-fledged Anganwadi centers, comma, there was no reason to deny their honorarium. Full stop. The learned counsel, by drawing the attention of this court to the communication dated 27/7/2009, has submitted that so far as an Anganwadi center is concerned, comma, the same is required to be manned, M-A-N-N-E-D, by one AWW and one AWH, and only for a mini Anganwadi center, there would be one AWW, full stop. He clarifies that in the instant case, comma, all the three centers in question are full-fledged Anganwadi center, wherein there is a requirement of one WW, one AWW and one AWH, full stop. The Learned Council has also drawn the attention of this court to the interim order dated 29/11/2017, passed in this proceeding, whereby the impugned order dated 22/5/2017 has been stayed, full stop. Para. The Learned Council, however, fairly submits that due to want of recent communications, comma, he cannot submit with certainty as to whether the petitioners are still rendering their service, full stop. Para. 3. Ardhar, the Learned State Council, on the other hand, has submitted that the Director, Social Welfare, had the occasion to deal with the matter for the first time only during passing of the impugned order dated 22/5/2017, when the records were properly verified, full stop. He submits that it was at that point of time that the anomalies were noticed, and also the role played by the district social welfare officer, Kachar, by the concerned district welfare, concerned to Humadiba, full stop. He points out that apart from the direction to terminate all appointments in the concerned 3 Anganwadi centers, comma, action against the concerned district social welfare officer, comma, Kachar, was also directed, full stop. The State Council submits that the appointments of the petitioners being done without following the due process of law, comma, the petitioners are not entitled to any equitable relief, full stop. It is also submitted that the entry of the petitioners in their services being without the properly conducted recruitment and being without following the due process of law, comma, their claim, they will not have any legitimate claim for their honorarium, full stop. Para. The Sri Laskar, the Learned Council for the petitioners, has however submitted that prior to this case, comma, there are 2 earlier writ petitions where the present stand was never taken, full stop. He further submits that it was only after institution of a contempt case that a stand was taken by the director, social welfare in the affidavit filed in the said contempt case that the concerned file was misplaced. It is submitted that when the petitioners had duly furnished the orders of this court, such stand is not acceptable. Para. The rival contentions have been duly considered and the materials placed before this court have been carefully perused. Full stop. Para. The present writ petition is the third round of litigation pertaining to the claim of honorarium by the petitioners. Full stop. The first writ petition WPC 1987/2012 was disposed of by order dated 25/5/2012 by directing disposal of the representation. Full stop. The representation was disposed of by the speaking order dated 24/7/2012, which was, however, not by the director of social welfare, but by the district social welfare officer, Kachar, wherein steps were directed to be taken for payment. And in that regard, a communication was also issued on 31/7/2012 to the director. Full stop. As the honorarium was not released, the petitioners had filed the second writ petition WPC 2242 of 2013, which was disposed of on 31/5/2013 by directing to take steps for such release. Full stop. It was only after forwarding of the aforesaid order, the aforesaid order was forwarded to the director immediately. Full stop. It is long after about 4 years that the impugned order has been passed on 22/5/2017 by the director. Full stop. This court has also noticed that the order has been passed after the petitioner had to take recourse to the Contempt of Courts Act as there was no compliance. Full stop. Para. Though the director, social welfare has placed on record the stand in the contempt petition that consequent orders could not be passed immediately as the file was misplaced, that may not be a sufficient reason for the long delay of about 4 years in considering the case of the petitioners. Full stop. Para. Be that as it may, without going to that aspect of the matter, the reasons assigned in the impugned order and the method adopted for arriving at the findings are required to be examined. Full stop. Para. Examined. Full stop. Such examination is required in spite of the fact. No, para, no. Though there were two earlier writ petitions filed by the same petitioners, this court has noticed that the disposal of the first writ petition vide order dated 25/5/2012 had led to passing of a speaking order dated 24/7/2012 by the district social welfare officer, wherein there was a direction towards payment of the honorarium. Full stop. The said order would reflect that at that occasion, no role was played by the Director of Social Welfare. Full stop. The role of the director is reflected only in the impugned order dated 22/5/2017, wherein the director has noticed gross anomalies in the appointment of the petitioners. Full stop. It has been noted that the aforesaid three numbers of centers were mini Anganwadi centers, and without proper verification, the appointment process was made at the behest of the district social welfare officer, Kachar. Full stop. The director has even noted that due to the anomalies / mistake, the petitioners were appointed in many Anganwadi centers, which was not permitted in law. No. The petitioners are appointed in the full stop. As noted above, in a mini Anganwadi center, only one appointment can be made, unlike a full-fledged Anganwadi center, wherein two appointments, one as AWW and one as AWH can be made. Full stop. The director had accordingly given a finding to terminate the services of the persons who were appointed in the aforesaid three concerned Anganwadi centers with immediate effect, and also to take necessary steps for engagement of Anganwadi workers in those mini Anganwadi centers. Full stop. Para? No, para no. As noted above, disciplinary proceeding was also directed to be taken against the concerned district social welfare officer and the child development project officer. District social welfare officer, Kachar, and the child development project officer, Banskandi, BANSKNDI. Full stop. Para. Though the verification exercise by the director on the status of the Anganwadi centers may be correct, comma. The action to terminate the petitioners from their services without giving them any opportunity may not be, is not permissible under the law. Full stop. The law envisages and law mandates that before any adverse action is taken by an authority, comma, the incumbent is required to be given a notice, and in this case, notice and opportunity, and in this case, comma, no such opportunity appears to have been given. Full stop. It is also not the case that the induction into the service was by any fraudulent activity or by forgery. And it appears that there were some misinterpretation misinterpretation regarding the status of the Anganwadi center. Full stop. Even if such misinterpretation is held to be, is assumed to be done by the concerned officials intentionally, comma, the petitioners would still be entitled to be given an opportunity before any adverse action. Full stop. This court has also noted that the impugned order has been stayed by this court in this proceeding wide order dated 29/11/2017, which has been extended from time to time. Full stop. Para Sri Laskar, comma, as recorded, Sri Laskar, the learned counsel for the petitioners, has already submitted that he doesn't have the present instructions regarding the aspect as to whether the petitioners are serving or not. Full stop. Para. Be that as it may, comma, this court is of the considered opinion that the decision to terminate the services of the petitioners contained in the order dated 22/5/2017 cannot be sustained, as the same is not preceded by an opportunity to be given to the petitioners. Full stop. Though this court would refrain from making any observations regarding the reasons to terminate, comma, the impugned order dated 22/5/2017 is set aside to the extent that in case the appointments of the petitioners are held to be not in accordance with law, comma, any decision to terminate their services are required to be preceded by an opportunity to the petitioners. Full stop. As a corollary, comma, it is also directed that an exercise be that for the period the petitioners have rendered their services, comma, their honorarium is required to be paid. Full stop. Para. The aforesaid exercise of payment as well as for giving a notice and notice to the petitioner, then take consequent action on their, on the aspect of their appointment vis-a-vis their continuation be completed within a period of 2 months. Mr. 2 months? 2 months from today. Full stop. The writ petition accordingly stands allowed to the extent mentioned above.
Obliged.
May I please adjourn the
Yes.
So the petitioner before your lordship to join his service in
CCC.
Mr. What junior of Mr. Y Dolo to get action. Here for days of difficulty. He is also no
Yes, what is the matter? 17 matter.
such. 99. So he was serving as Malad constable in BSF Malad. And while Malad working, he fell sick and prayed for RT, and he was section Malad RT of 1 month Malad 25/9/13 to 24/10/13. Then Malad after coming home Malad he seriously fell sick Malad that could not join service. Then Topos notice was served upon him Malad on 25/14 Malad, and he filed his reply, but Malad could not place it before the honorable court as it was missed. So he filed after that Malad, he after for his service Malad, he filed his preparation test in India 2017 Malad, so it was after 3 years. So then he come to know that he has been dismissed from service Malad. So that is it. He was he annexed some documents Malad in medical treatment. So
Your sanction was for 1 month.
1 month.
Then when did you join?
Then he did not join, but he fell sick Malad. He fell sick, seriously sick Malad. He came to his Malad native place Malad, and then he could
What
not
was the
join
sickness?
Malad. So
What ailment?
Malad, he was mentally Malad not. He suffered from earlier Malad depression. Then he is mentally sick Malad, mental problem Malad. That your lordship will
Mental
find-
problem?
Lordship, he was suffering from mental disorder Malad.
Where?
Malad, he treated in Malad that CHE Malad, lordship will find
Mental disorder.
mental impairment Malad. Lordship
Hmm?
will find page 12 Malad.
Page 12.
12. Liver disorder and mental impairment. Salicide and leg, which is he need rest and Malad. This is his 4/7/2013 document. Then again Malad, the next document 6/4/2004. Sorry, 4/6.
Where is the mental element, madam?
This is the document Malad. I
There
can't.
is no mental element.
So
He suffered
it
from-
is Malad, page 12, Malad, liver disorder, mental impairment,
Cellulitis of the leg.
leg, then Malad and Malad. Your lordship, mental impairment and leg. He has got 3 diseases shown in this
There is no mental and
2013 document. I can't explain more than that. Malad, after he was fit for service,
Thereafter?
Malad, he went with a representation, and then he come to know that he has been dismissed from service. But
Now, were you an in-house patient?
yes, Malad,
Where?
he was not admitted in a hospital. He was admitted.
No, he was not in a hospital. He was
No,
not
no,
an
no,
in-house
he was
patient.
not admitted. He was not admitted. He was attending only Malad
As an
CHE
OPD.
OPDs.
OPD, you're a serious patient.
Malad mentally, he was depression, suffering from depression. Then Malad mentally. They have filed a affidavit, my lord. They have stated that, my lord, they have
Pathetic.
assigned, my lord, one person to visit his house, my lord, and nothing more than that, because they have not issued any ID card, but sent to the, they have not produced any ID card, which was sent to his residence. Only they have stated that, my lord, lordship will find their affidavit,
No, if you're having some ailment
lordship.
mentally, can you serve?
Oh, my lord, that is also because they have stated that it was served upon the petitioner, my lord, in that. But
No,
my
no,
lord,
can you serve your organization with this problem?
my lord, now he has recovered, so that's why in the year 2017 he approached. Lordship will
Where
find,
is your recovery?
lordship will find page 31.
3-1.
True. Then my lord, same hospital.
Is it? Not convincing, madam.
Okay, so documents are not convincing, my lord, I understand, my lord. But they have not stated that it was served upon them, my lord. Notices were, only they have stated your lordship will find. Because documents are, my lord, because within 5 months of time, my lord, he has been dismissed from the lordship, lordship will find. He was on sanction leave, my lord, from 25/9/13 to 24/10/2013. And as per their document, my lord, he has been dismissed from service with effect from 18/3/2000. So, my lord, within 5 months.
It's a
of being-
BSF.
BSF,
BSF.
my,
5 months. You're saying 5 days may also be fatal.
my lord, but
5 months you are not there.
there was no other reason to join in, my lord.
Where is the information you had given them?
Lord,
Where is the information that you are not well, cannot join?
that is
If
missing.
that is
here,
not there,
That is missing.
you
But
may,
then I-
in a given case,
Lord.
you may seriously fall ill, but you have to at least,
My lord,
you or your family members have to inform them.
that, my lord, though it is
Okay, we'll
not
come back at
convincing,
2 o'clock.
Lord,
But results may not be very good for you.
Lord, I have seen from the record, but my lord, they have also not, my lord, produced a document whereby, my lord,
It's your case.
all the notice.
It is your case. It's not their case.
They have not produced any of the documents, my lord,
First
Whereby-
you have to discharge your burden, then only the onus,
because he was,
then only the onus might go to them. We may not even hear them.
my lord, I.
Okay, at 2 o'clock.
Lord, obliged.
You try to have some CGC, Mr. Okay, you just have a look at the court records. And maybe perhaps we change our mind,
Deeply obliged, my lord, deeply obliged,
but very little scope.
lordship. But if from record, my lord, I have seen, but my lord, he was, my lord, not well. He has filed his reply, and my lord, they have completed the, my lord, process of dismissal, my lord, within 5 months. No, they have not even produced, my lord, that all the copies were sent to the, my lord, petitioners, my lord, whether he has received. There
What
must be some
copy?
amendment, my lord.
What copies?
My lord, copy for, my lord, initiation of departmental proceeding, my lord, the dismissal, my lord. Because only he has received the, my lord, show cause notice, and that he has replied, my lord, he has not copy with that. But, my lord, after that, the process of, my lord, the departmental proceeding, my lord, started, when they have initiated the proceeding, my lord, after show cause, those documents are not, my lord, served upon the petitioner. So they have, my lord, annexed one letter that they have deputed one Mr. P. Bora to his residence, my lord. And after that, my lord, what happened, my lord, that is not in the record, my lord.
Were you aware of the proceedings?
No, my lord, show cause notice, see, he has received, my lord.
No, that is it, that you have already said,
My lord,
that you
yes,
have replied to the show cause notice.
I have replied, but.
Thereafter, there was a proceeding, are you aware?
No, my, no notice was served after that. Whatever he has got, my lord, he has placed before this honorable
Where
court.
is your reply?
Reply is not, my lord, he has not kept it. That
Mhm.
is, my lord,
Noted.
not, he was not, when I asked, my lord, he was not having it. He said, my lord, I have replied, but after that, I thought they will consider my case. Because he has submitted as per his, my lord, contention, he has, with his medical document, my lord. Because he has treated his disease in the, my lord, CHE.
Yes, Mr. Roy.
To have done the court document, in the affidavit document, it is stated that one person was deployed to inform him about the absence lordship, why he is not joining. The movement order is annexed.
Where is
And-
the statement in the,
Affidavit in page number 34.
you have filed affidavit?
Yes.
Okay.
But in the running page,
Hmm.
then page number 2.
Yes.
The third paragraph, on receipt of the report from the unit CTN treatment, so overseeing leave was informed that is from the section leave and directed to join the chief, telling which disciplinary action would be initiated against him. By the office registered, but no publication was further. As per instruction, each to turn sections, CSF Court of Inquiry to investigate the circumstances under which was overseeing leave was ordered by so and so.
Yes.
During the court of inquiry, petitioner was found overseeing according to survey. In addition, a representative number so and so, General TDP Bora from his unit was also sent to his hometown to ascertain the reason of his overstay of leave and to know whether he is willing to serve in BSF or not. By this unit movement order dated since above representative visited.
Well, you did
the-
not even reply.
No.
Pilot, because he was not in that state, man.
No, you did not even reply to the show cause notice.
Yes.
Yes, so
That was
as
also
per
there.
his contention, he has replied.
No,
ma'am.
that-
That is since it is, I could not produce it, but even then after date also, my lord, they ought to have, even if my lord assuming he did not reply, my lord, after the initiation of the proceeding, my lord, they ought to have, my lord.
When you
given,
have not even responded.
my lord, as per his contention, he has responded. But
No,
now
contention will not do.
Lordship,
When did you respond? You may not have the copy. Let us assume
No,
that,
he
let
was
us
not-
accept your,
he was not keeping well, so that's why, my lord.
let us accept your,
Lordship.
of your contention that you do not have the copy. When did you, by
Yet also he could not recall, my lord.
by what mode did you
Because-
send?
2017, my lord, he filed.
Have
a
you
statement.
filed a rejoinder to this?
No.
My lord, because I lost his contact also, my lord. I'll have to send him the registered postman. Because.
No, have you filed any rejoinder to the affidavit?
My
No.
lord, I could not file. Because I lost the contact, because he's in a very remote area of.
You have done more than enough as a council.
Let them consider his, my lord, again, my lord, if at all, my lord.
We
Because
we
he is only 47
we
years old.
appreciate your sincere efforts. Heard. Miss U. Das, Learned Counsel for the petitioner. Also heard Sri S.S. Roy, Learned CGC, appearing for all the respondents.
Okay.
Para. Please have your seat. The petitioner has put to challenge the action of the respondent authorities in not allowing him to join his duties as constable in the BSF,
Yes, sir.
Border Security Force, within bracket BSF. Full stop, para. The facts projected is that in the year 1999, comma, the petitioner was appointed as a constable, and while working in the decoy of the unit of 124 Battalion, BSF, comma, New Cooch Behar in the state of West Bengal, comma, he fell sick and had accordingly prayed for and was granted earned leave for the period 25/9/2013 to 24/10/2013. Full stop. It is the case of the petitioner that after coming to his native place, where do you stay?
Sorobog, Malat.
Sorobog.
Borpeta, Malat.
Sorobog, you are busy with, you're busy feasting in Sorobog,
Borpeta, Malat, sorry, PO Borpeta Road, District Borpeta.
place of Bhog.
Sorry. Yes,
We know what you are doing at your home. In the district, after coming back, native place in the district of Borpeta, comma, he had further health problems, as a result of which he could not return for his duty. Full stop. The petitioner alleges that he had both physical ailment as well as mental ailment for which he was treated. Full stop. Para. Due to his absence, comma, Ashoka's notice was issued on 25/1/2014, directing him to submit his defense. Full stop. The petitioner claims to have submitted a representation in response to the same, which, however, he could not trace out, for which, however, has not been annexed to the petition. Full stop. It is submitted that the reason for the same is not being able to trace out the copy of the said representation. Full stop. Para. Ms. Das, the learned counsel, has submitted that after getting the clearance from the doctor, comma, the petitioner had visited the office of the respondent number 2 with the necessary documents, with the necessary medical documents to resume his duties, which, however, was not allowed, and rather the petitioner was informed that he was dismissed from service for unauthorized absence. Full stop. The learned counsel has submitted that the entire action was done behind the back of the petitioner without affording him a reasonable opportunity. Full stop. The challenge is also based on the grounds of lack of transparency and fairness, by which an adverse action has been taken against the petitioner without following the due process of law. Full stop. The learned counsel accordingly submits that appropriate orders / directions be issued to allow the petitioner to resume his duties in accordance with law. Full stop. Para. Per contra, comma, Sri Roy, the learned CGC, has submitted that the projection made by the petitioner are incorrect both on facts and in law. Full stop. It is submitted that the petitioner had overstayed his leave and was unauthorizedly absent from duties. Full stop. He submits that the nature of duties and the organization in which the petitioner was employed is of utmost importance, directly related to the interest of the country. Full stop. Though the petitioner was granted earned leave from 25/9/2013 to 24/10/2013, comma, he did not report for his duties. Full stop. By drawing the attention of this court, by drawing the attention of this court to the averments made in paragraph 2 of the affidavit in opposition filed on 14/6/2018, comma, the learned CGC has submitted that on the petitioner not having returned for resumption of his duties, comma, various communications by registered post, including letters dated 28/10/2013, comma, 8/11/2013 and 16/11/2013 were issued to him, which were not replied. Full stop. Accordingly, comma, as per section 62 of the BSF Act, comma, a court of inquiry was held to investigate the matter. Full stop. An apprehension rule was also issued to apprehend the petitioner on 24/12/2013, which, however, for 2013 first, however, no response was received from the concerned police authorities. Full stop. In the court of inquiry, comma, it was found that the petitioner was overstaying the leave without any valid reasons. Full stop. Para. Accordingly, comma, a so-called notice was issued to the petitioner by registered post on 25/1/2014, by which the petitioner was directed to submit his defense, failing which, comma, it was stated that the petitioner had nothing to say in his defense. Full stop. Though the communication was received, comma, no response was filed. Full stop. Para. Sri Roy, the learned CGC further submits that to give a further opportunity, comma, a representative number 86007276 ASI within bracket GD bracket close P Bora of the unit was sent to the residence of the petitioner in his hometown to inquire about the petitioner and to ascertain as to whether the petitioner was willing to serve the organization or not. Full stop. The representative on his visit was, however, informed by the petitioner that he was not willing to resume his duties or come back to the organization. Full stop. It is long thereafter, by giving adequate time, comma, an order was passed on 25/10/2013 dismissing the petitioner from service, and the said order of dismissal was also communicated to the petitioner via registered post. Full stop. Para. It is submitted by the learned CGC that long thereafter, the present writ petition has been instituted in the year 2017. Full stop. He further submits that the services under the BSF, which is a discipline force, cannot be neglected or treated in the instant manner, and therefore no relief is entitled to by the petitioner. Full stop. Para. The rival contentions have been duly considered, and the materials placed before this court have been carefully examined. Full stop. Para. The factual assertion made by the petitioner in the writ petition have been categorically denied in the affidavit in opposition filed by the respondent numbers 1 and 2 on 14/6/2018. Full stop. No rejoinder of any nature has been filed by the petitioner. Full stop. Ms. Das, the learned counsel for the petitioner, however, has fairly submitted that the petitioner is not presently in touch, and therefore such rejoinder could not be filed. Full stop. Para. Be that as it may, comma, the material, the pleadings, the rival pleadings and the materials on record would show that the only reason which has been cited by the petitioner in the instant petition is being is suffering from certain liver ailment as well as mental ailment. Full stop. What is, however, important to note is that though the petitioner has claimed to have replied to the show cause notice dated 25/1/2014, such copy of such reply has not been annexed to the writ petition, and the ground assigned is that the same could not be traced out. Full stop. Juxtaposed, the relevant readings in the counter affidavit is that the petitioner never replied to the said show cause notice. Full stop. The show cause notice, along with the earlier communications noted above, have been annexed to the affidavit in opposition, and there is no response as indicated above. Full stop. The respondents did not straight away pass any adverse order, but had further sent a representative to the residential home of the petitioner, who had met the petitioner, wherein the petitioner had expressed his disinclination to continue in the service of the BSF. Full stop. The aforesaid statements have not been denied. Full stop. The dismissal order has been passed after about 6 months thereafter, on 25/10/2013, which was also sent to the petitioner by registered post. Full stop. Para. And para no. The said dismissal order, however, has not been specifically challenged. It is not the subject matter of challenge. Full stop. The writ petition itself has been filed after about 3 years from the said date in the year 2017. And there is no cogent and acceptable reasons for the same. Full stop. Though a statement has been made that the petitioner was suffering from ailment, and certain documents have been annexed, those in the opinion of this court are not sufficient and would rather appear to be made as an afterthought to cover up the lapses. Full stop. Para. The exercise of jurisdiction under Article 226 of the Constitution of India has to be done in an equitable manner, wherein the conduct of the rival parties is of paramount importance. Full stop. Under the facts and circumstances of the said case, this court is of the view that equity would not be in favor of the petitioner. Full stop. The writ petition accordingly stands dismissed.
So the dismissal order will be 18 March 2014.
14, not 13.
14.
2000?
14.
We said
18th
14.
March 2014.
What did we say?
13.
13.
14, huh? 18 March.
Yes.
Next day,
18 March 2014.
14.
Oh, 14. Show cause to 13 or still?
Lot. Locus was 13.
13? 18 March 2014. Okay.
So that
This case of the petition number 1 has been promoted, sir. First, we consider the case of number 2 also.
Two petitioners are there.
two petitions were there, Lordship. Number one was promoted, Lordship. And 7 years they took the time to consider my,
The prayer is
because they were from,
Now, what
they were in, both were in grade 4, Lordship. And as per the relevant rules, Lordship, this should have been considered for grade 3, Lordship. After completion of 7 years,
He
Lordship,
did.
there are some municipal district establishment service groups.
he is a 12 pass lordship, so accordingly he is will be promoted to the particular sector assistant like. Not to
You-
the post of
you-
junior, not to
You,
the
do-
post
you
of
don't
junior,
need a graduate.
otherwise graduate lordship.
In
But
all
some posts are there lordship, which can, I think in the APPO is there, but
In the education department, can you make a differentiation with regard to the educational qualification which require in respect of a particular cadre?
not my lordship oral instruction.
No, no. How can a higher secondary become, be eligible to hold the post of a grade 3?
Lordship, in education department, there is a lot of such post, Lordship, education. Even in education.
No, no, here we are considering irrigation.
Irrigation also, Lordship, there are
Now
posts,
show us, what is the requirement?
Lordship, that I can place, Lordship, that I can place. Number of posts are there,
Where higher secondary is
Lordship.
the,
Lordship.
let us see.
Not right now, Lordship, but I can show you a lot.
Now you take the rules. What rules do you need? So, which rules are you in requirement?
Lordship, not as rules of advertisements, Lordship, that they make, Lordship, for grade 3.
Advertisement will not determine. We have to take a decision in accordance with law.
Lordship, rule.
If in the rules you can show any post in the grade 3, which
Lordship,
as on present it can be held by a person at higher secondary.
Lordship.
Now you may be right, but you have to show us. We do not know. Our impression is it's minimum is graduation. Asane amar Herikon.
If Lordship grants me some time, Lordship, I can place.
We can have it tomorrow.
Not tomorrow, Lordship.
Tomorrow, these are all matters.
Day after tomorrow. One day.
Day after Wednesday again, we will have number of motions or something. Second, क्या बोले? First one, third. Oh. Day after tomorrow.
Or Lordship can do one thing, Lordship. They will consider if posts are available, Lordship, in grade
No,
2. If they,
without,
that can be
without,
accommodated.
no, we cannot pass those kind of orders.
I don't know.
Without
the
we
same-
being satisfied, how should why should we give the burden to somebody else? If it is permissible, it's permissible, we'll
Got
hold
it.
it. It's not
Got it.
permissible, why should we?
Lordship.
Day after tomorrow. On request, list day after tomorrow.
Right.
Not only in the morning, my lord, some prayer was made. Logically accommodate me for the day, my lord. I couldn't prepare the case. Last
18 matter.
first time, my lord.
You start off, we'll see. What is the
Last
topic.
2 days, my lord, I was out of station. That in the, my lord, testimony of our mother. So, my lord, I could not.
Okay, then tomorrow?
Day after tomorrow.
Tomorrow.
Tomorrow, my lord,
Tomorrow.
I have 4 cases.
We'll accommodate you tomorrow. On request of 3.
Day after tomorrow, my lord.
Tomorrow, day after tomorrow, we have already fixed the case. Tomorrow, we'll
Then, my
accommodate
lord,
you.
Thursday,
in court number one,
Good things should not wait. We not know, it may be allowed in your favor.
it is very tough case, my lord, for me, my lord.
And you know that means.
Not feeling.
Today you are not feeling well, tomorrow you'll be feeling well.
Ah.
Okay. Tomorrow, on the request of three. Take a Purgasto list tomorrow. Yes.
Tomorrow, then lordship is second up.
We'll accommodate, don't worry. Yes.
May I please, your lordship? Lordship, in this matter, your lordship, an advertisement was issued in the year 2014 of filling of the vacant post of technical assistant and regular in the social welfare department.
Okay.
But accordingly, we the petitioner appeared in the interview, passed out the written, and we were.
When
called-
was the advertisement?
It was 24/2/2014.
5/1/80/19. 20?
4/2/2014.
28th of April,
24th February 2014.
24/2.
Yes, lordship.
24/2/14
2014.
advertisement
Lordship.
for statistical assistant.
Statistical assistant of the social welfare department on a regular basis.
How many posts?
24 posts were there.
Okay, then
Then accordingly, on 13/12/2015, written was conducted.
13/12.
2015.
You participate in the
In the
advertisement,
written, yes, sir.
written test.
Yes.
Okay, then
Thereafter, your worship, we were called for the viva voce. We cleared the written. We
you are
Clear.
shortlisted in the written
the
examination.
lordship.
How many of you are there? One,
Three of us.
three petitioners.
Yes.
Petitioners qualified in written,
Yes, sir.
call for viva voce.
Viva voce.
Yes,
And 17/2, your lordship,
17 to 15,
16,
16.
lordship.
In between 1 year had gone.
Look on, yeah. The
16.
final results were declared.
Okay.
And accordingly, we were 24 candidates were selected, in which our name.
You are
Okay.
selected.
Yes, your lord. Accordingly, your lordship, now there comes the interesting point. On 22/2016, accordingly, we joined in the direct train,
20th of February,
20th February.
you joined.
Joined. 17 results were declared, and on 22/2016, we joined.
Correct.
In the meantime, what happened, lordship, one Punmani Bora, who did not find place in this select list, approached before this honorable court by filing a writ petition and challenged 4 candidates' candidature that they did not appear in the written test.
Or
But-
name, number, WBC,
1 2 3 5.
1, 2, 3, 5 by an unselected candidate.
Wow,
1, 2,
yes,
3, 5 of 2016
2016.
by one Sunmoni.
Tunmani Bora.
Sunmoni.
Tunmani. TUN.
Oh, Tunmoni.
Tunmani.
What was the allegation? 4 candidates?
The 4 candidates, the allegation was that we did not appear in the written test.
You also,
We also.
Oh.
The 3 are here in this petition.
including petitioners, did not appear.
In the written test, but we were called for the viva voce.
Okay. Then what happened in that case?
Yeah. In that case, your lordship, the interesting part is that we were not made a party in that case.
Oh.
But the honorable court on 24/2/16 by order and judgment stayed our selection
24?
2016 immediately.
Okay.
Thereafter, lordship, we got implicated in this matter in
Mm.
2018. As we didn't have any information regarding this, we implicated in this matter. Thereafter, on 21/6/2018,
Yes.
this honorable court, after hearing the whole matter, vacated the stay.
Mm.
Vacated the stay and dismissed the writ petition.
Thereafter, we submitted a representation regarding all this and informed the department that the stay was vacated. And accordingly, on 10/8/2018, we were posted in different SEDS projects.
Okay.
Therefore, in the meantime, one of the candidate who was also in the case given by Kulmani Bora, he was placed in, immediately after joining, he was placed in the posting. Place of posting was given to him, but we three were not given, citing the reason that there is a stay. So accordingly, on 10/8/18, we were given posting.
Posted, oh,
Thereafter, that is our grievance that as we had joined on 22/16, we prayed that our initial date of joining should be accepted as 10/22/2016.
okay. When was the first order? Order was stayed. 24 was the order of stay.
Your Lordship. That too without making us party.
Okay. You want that your,
The initial
the effect of
yes.
your joining should be given from the
22
date when you are given. the-
initially joined
Okay,
people. Lordship.
okay.
That is our prayer.
Okay, yes, yes, Mr. Bora.
Lordship, this matter as such, after a very long time. So the year 2022, on 24/22, it came up then the petition sought adjournment. Then again, of course, we have not filed any affidavit in the meanwhile, but we have actually received this instruction from the department, from Director of Social Welfare. Now, of course, this moment is child. Therein the director wrote on 27 September 2019,
Yes.
the additional chief secretary, Social Welfare Department, then seeking regularization of their service, even notional benefits for the petition. So, Lordship, at this stage, Your Lordship, if I may, say that this particular, that the government take a decision on this.
No, they were not at fault.
They're not at fault. They're not at fault.
Somebody filed a case, he may have a genuine reason or not, but ultimately when the case was dismissed and the stay vacated, thereafter, and out of these four, one was given the place of posting.
Yes.
And since they are not given, this may not be fair. And in fact, the director had taken a very neutral kind of a
Yes.
stand. Okay. I Ahmed,
Lordship.
heard Sri I Ahmed, Learned Counsel for the petitioners. Also heard Sri D. Bora, Learned State Counsel, appearing on behalf of all the respondents. The petitioners, who are three in numbers, have approached this court with a prayer to give effect of their joining in service as statistical assistant in the Directorate of Social Welfare from 2016. Full stop para. The facts projected is that pursuant to a recruitment drive wide, an advertisement dated 24/2/2014 for the post of statistical assistant in the Directorate Social Welfare, the petitioners had offered their candidatures. Full stop. It is the case of the petitioners that for filling up of 24 numbers of vacancies, the written test was held on 13/12/2014, in which the petitioners had come out successful and were accordingly called for the Viva Voce. Full stop. After completion of the process, comma, the final results were declared on 17/2/2016, in which the petitioners were held to be selected. Full stop. It is contended that on such selection, comma, the petitioners were appointed and they had joined the services on 20/2/2016. Full stop. Para. The problem, however, started when one of the unsuccessful candidate, namely one Tunmoni Bora, had instituted WPC 1235 of 2016, challenging the selection with the specific allegations that 4 numbers of candidates who were held to be selected and includes the present petitioners did not appear in the written test. Full stop. Accordingly, comma, on 24/2/2016, an order was passed by this court staying the appointment orders. Full stop. Para. It is the contention of the petitioners that they were not made parties in the said writ petition, and accordingly, the petitioners got themselves impleaded in the said writ petition in the year 2018. Full stop. Subsequently, comma, on 21/6/2018, the aforesaid WPC 1235/2016 was dismissed and the stay order was vacated. Full stop. Thereafter, comma, the petitioners were given their postings on 10/8/2018. Full stop. Para. Sri Ahmed, the learned counsel for the petitioners, has submitted that while the allegations in WPC 1235/2016 were against 4 numbers of candidates, comma, so far as one candidate is concerned, comma, he was given a place of posting prior to the order of stay, and therefore he had continued. Full stop. However, comma, since the petitioners had joined the services on 22/2016, were not given their places of postings, which was subsequently given only on 10/8/2018. Full stop. The learned counsel accordingly submits that the petitioners are entitled to afford the benefit from all service benefits from the date of their joining in service. Full stop. It is further submitted that the gap in the interregnum was not because of any fault of the petitioner, but because of a proceeding in this court which was instituted by an unsuccessful candidate, in which the petitioners were not even made parties. Full stop. Subsequently, the said writ petition was also dismissed on 21/6/2018, and only thereafter the petitioners were allotted places of postings. Full stop. Para. Sri Bora, the learned State Council, submits that though affidavit in opposition has not been filed, there is a communication dated 27/9/2019 by the director to the department in connection with the present case. Full stop. The director had also opined that though the petitioners had joined on 22/2016, since they were not in service for the gap period with effect from 22/2016 to 9/8/2018, they may be entitled for notional benefits. Full stop. Para. After consideration of the rival submissions made by the learned counsel for the parties, this court is of the opinion that there is no dispute with regard to the selection and appointment of the petitioners. Full stop. The issue which was tried to be raised on their selection has also been put to rest by this court in dismissing WPC 1235 2016 wide order dated 21/6/2018. Full stop. It is also not disputed that though the allegations in the aforesaid WPC 1235 were against 4 candidates, including the 3 numbers of petitioners, since the 4th candidate had in the meantime was in the meantime given a place of posting, his service has been held to be continuous since such place of posting, and only the petitioners have been deprived of their continuity in service because of the court's proceedings. Full stop. It is a settled law that orders of this court or pendency shall not be to the prejudice of any parties. Full stop. The dismissal of WPC 1235 2016 by order dated 21/6/2018, wherein the initial order of stay was vacated, would also be a relevant factor. Full stop. The petitioners, now in the opinion of this court, the petitioners cannot be faulted with the delay in their allotment of places of postings, and it is only a matter of chance for which, though they had joined their services on 22/2016, their places of postings could not be given immediately, and in the meantime, there was a stay order of this court on 24/2/2016, which was in operation till 21/6/2018. Full stop. Para. In view of the aforesaid discussion, comma, this court is of the view that a case of interference is made out, full stop. It is accordingly directed that the petitioners are deemed, petitioners be deemed to be in continuous service since 22/2016. That is the date of their joining as statistical assistant in the Department of Social Welfare, Assam, full stop. However, comma, such direction would be restricted only to giving the national benefits, including the present fitment, and would not include the aspect of any back wages, full stop. Writ petition accordingly stands allowed in the manner indicated above. Copy of the instructions dated 27/9/2019 is made part of the records. You have copy?
Yes.
If this is the original, we can make a photocopy.
No,
We'll make a photocopy.
I have to on the original. This
No, we'll
particular-
make a photocopy. This is a signed copy. We will not retain signed copy. This is not marked to the, এটা photo রাখিবা, huh?
Develop. This records were called for lottery. But the record, so my instruction records are not visible.
What is the matter, Mr. Pathak?
Not, this relates to promotion, but then the issue is that this particular individual was serving as Assam Rifles, my thought. He had suffered from some injury during the training period.
Okay.
Now, Assam Rifle initially said that your training period is not on active duty and therefore your promotion will not be considered. Because if you are injured in, my lord, active duty, even though you are medically not 100% fit, promotion, there is a relaxation.
Okay. But
My
not in
promotion is now held up, my lord. But then the convening medical board that was perfectly convened, but it had said that there's an injury attributable.
No, the distinction has been sought to be carved out so far as suffering of injury in the training period as well or in duty period.
My lord,
Training has not been taken to be duty period.
not
By
been
them.
anticipated,
That is the issue.
my lord. That is
Yes,
the-
what is your justification?
Lordship, that the court of, they were said that there was a court of inquiry. Lordship, we are searching for that court of inquiry reports, Lordship. That was not, whether he was really, the persons were examined or not, Lordship. On that basis, because that court of inquiry held that he had attributable to the government law. This injury. But in our affidavit, they can send, Lordship, not attribute.
No, we'll go by the materials, whatever is there.
Because,
You
Yes,
file
sir.
affidavit otherwise.
yes. Reply also, pleadings are complete. Lordship, the date me for the
Today is the date.
date of the
We have fixed the
Today.
date. We have not fixed the date. Somebody else has fixed the date.
Not. date of
Because the medical board, they have
When
conducted,
the
my lord,
case
it
has
is
been
there
destined to be
for
heard today, it should be heard today.
At case 25 now, they seek to deny their own board, my lord. which
Yes,
is given
tell
a-
us the facts. 5/8/3/2/19. B. Pathak. S.S. Roy. Okay. Tell us the facts.
I pay for it, but because I've not. completely
By
prepared.
the time Mr. Pathak could take, you go by the records. We have already said good things should not wait.
No.
Yes, what is it?
My lord. If some state rate, there's no dispute that there was some injury, my lord.
No, no, you
Then the
tell,
controversy started, my lord, from Annexure 6, my lord.
Now you tell us the basic facts. Who are you? 95 you had got into the service
I got enrolled, my lord,
in Assam Rifles.
in Assam Rifles.
As what? Lance Naik.
That's my writer.
Writer means
Earlier, my lord, these clerks were called Landsberg right.
writers.
Subsequently, this has been redesignated as clerk. The word writer has been changed to clerk. And essentially, therefore, my duties are also, my lord, being a clerk, my lord, is mostly a
Their job.
administrative bench job,
Their
my
job.
lord. It's not a field job. And even though, my lord, the shape 1 is otherwise required for promotion,
Yes, yes. In Assam Rifles,
My lord.
95 you are enrolled.
my lord. In
Thereafter,
Then in 2005, my lord, Lord could see at page 5, the para 4, my pleading.
hmm,
2005, my lord, during a battle physical efficiency test training, my lord.
2005,
My lord,
after 10 years, some training,
my lord.
refreshment,
Physical training and
refreshing type of course. or
my lord,
what?
refreshing courses, my lord, just keep on happening.
Hmm. This is not the induction training
This is not the induction training.
or
I was already
in-house
already
training,
serving, already serving, my
routine
lord.
training.
My lord. It was a regular routine training, my lord.
Okay.
There I had suffered some incident.
Hmm.
There was a horizontal rope race and a rope break. The rope broke actually, and that led to a injury in my back.
Okay. You suffered injuries.
My lord.
Thereafter,
Then, my lord, because of that injury, my lord, subsequently, gradually my spinal health, my lord, it declined, and I was put in, my lord, shape lesser than shape 1. That is at page 6, my lord. Page 6, para 6.
what
My
is
lord.
shape? What is shape?
Shape is, my lord, the physical condition of a person serving in the armed
The
forces, my lord.
yardstick kind of a thing.
It is a yardstick, my lord. It assesses basically its psychological, arms, limbs, and other health conditions, including eyes.
SHAP.
PE.
E is not there. SHAP.
E is for eyes.
I is also there.
P is physical. my lord.
Where do you say?
I stand, my lord, at P3 now instead of P1. Other
No,
appendices
no,
are
paragraph 6.
para 6, my lord.
Where is that expression?
After discharge from the command hospital, Kolkata, the petitioner was placed in low medical category of shape SHAP P3 with effect from 19/1/2014 by the competent authority. Thereafter, there was again a recategorization.
No,
Also
where do you get E?
E is for eyes.
Where?
SHAPE E1 is E1, S1, H1, A1.
E. E is not
S is
there.
for my psychological, H is for hearing, A is for appendices, P is for overall physical condition, and E is for eyes.
No, where do you get E here?
E is there, my lord.
Paragraph 6.
Para 6, my lord.
Which line?
1, 2, 3, 4, 5, 6, 7, 8, 9, 10th line, my lord, from top.
Yeah, after discharge.
After discharge,
Yes.
E1. E is E1.
Is it E or is it 3?
Is E, man.
Lordship S1, H1, A1, P3, bracket
P3.
P, bracket P24,
Oh.
then E1.
Oh, E1 is separate.
E1.
What is T24?
T24 is
Temporarily for 24.
Okay. Oh,
weeks,
E1,
2 weeks, 2
E1
weeks.
is a part of the entire expression.
Weeks, not month.
Okay. 6.
So this condition keeps on getting reassessed. And
You were from what was your earlier category?
before that, my lord, it was shape 1. And in fact, for that, my lord, in fact, probably the previous medical records were
Now you have gone
got to be looked into by this.
Now you have
board.
gone to shape what? 3.
My lord, I'm still at P3. Still at P3.
All right. 2. Low medical category. Okay, then what happened?
And in May 2018, my lord, when my promotion was due, my lord, my promotion, my lord, could not take place at that point of time because I was P3, not P1.
No, when did you suffer your injury?
The injury was from 2005, my lord. And in fact, that is why, my lord, the
But
matter was-
why this reports are of 2014?
Came up for promotion on
at that point of time.
that point.
2014 consideration for promotion.
Yes.
You are held to be low category, low
Right.
medical category,
Low medical
denied.
Denied.
Then
And in Annexure 6 also now look, that as to the circumstances of my injury, my lord, there was a board that was convened, medical board was convened by the respondents themselves.
paragraph, page
It would be
19.
19.
page 19 onwards, Annexure 6.
19 is what?
The first page is a convening order.
Okay.
This was to investigate the circumstances under which so and so had sustained injury during BPET held in HU DCR Shillong on 15 September 2005. Then Annexure 7
Convening
is
order of what? This is what?
the convening order for a medical board, my lord. Medical board examine different aspects, my lord.
Okay.
And this was basically an inquiry into the circumstances. So the findings of that, my lord, body, my lord, that came at page 25. See,
It's a court of inquiry.
my lord, with the court of inquiry. Having examined witnesses in detail, the court is of the opinion that injury was sustained.
Which page?
Page 25, my lord, I'm reading. This would be part of Annexure 7.
25.
The injury was sustained by so and so during PPET test held in Assam Rifle Training Unit Shillong. The injury sustained was beyond his control and individual should not be held responsible for the same. The individual was on government, bona fide government duty, and so the injury sustained is attributable to Assam Rifle Service.
Okay.
And in Annexure 8, my lord, the commandant also concurred with the opinion of that
And
court.
page?
Annexure 8, page 26.
Okay. Yes.
Hello. And my lord, I represented again in Annexure 9 that my promotion should be reconsidered, my lord, because the board has
Page-
now
page-
given a finding.
Page
Page 27.
This is your representation. Dated?
It is dated 12th March 2019.
Okay.
But that was my representation that injury having been sustained in course of training and in course of active duty.
Your representation for promotion.
My lord. My colleagues were already promoted by that time, but then I was held behind. I said that my case should be reconsidered.
Okay.
And Annexure 11, my lord, they reply
By whom?
on 8 April 2019. Page 30. they say that the para 3, however, it is seen that this person of your organization was injured during QEBPT held by the headquarter DCAR and not on active government duty. Therefore, my case was rejected, my lord. And upon this.
What is
discussion-
QEBPT?
Better physical
Better
efficiency.
physical efficiency test.
Hmm. Okay. This is the order impugned.
My lord, this is the
30.
order. Now, in the affidavit, my lord, they again reiterated that I being in training is not active government duty. That is
Who-
one aspect. And secondly, they try to say that this board itself was not properly convened. They deny their own board.
Where has it been stated in the affidavit?
In the affidavit.
That is the stand.
That is the.
Two stands. What are the stands?
The first thing is that, my lord, they reiterated the fact that I was not in
There's a
active duty.
distinction between suffering injuries in a battle, actual battle
Active
and
government duty, it's not, training is not active government duty. That is what they try to say. And secondly, they say that, my lord, the board itself, we have read in 2018, my lord, which gave a finding. They
number
say that
two.
that board itself is not credible. They are denying the report of their
Or
own.
it was not duly constituted or was it not
I
competent?
don't know, my lord.
Now, what is their stand?
They simply say that it is not reliable or we don't trust it, whatever. It is
No,
conducted by their own officers, my lord.
No, Mr. Pathak, there will be two connotations. One is whether they are questioning the constitution of the board, number one, which will lead to the question of competence.
My lord.
And the other is, though the board has given a finding, we don't find that the findings are based on materials on record. Those are
Well,
two.
my lord.
Is the competence of the board doubted?
My lord, the language of the affidavit, my lord, it,
Competence of the board.
there's no clarity in the language in the affidavit.
But in any case, the board's findings are not acceptable for them.
My lord.
That is the final
That is,
conclusion.
that is the.
Okay, then. That is all?
That is all, my lord.
Okay.
These are the facts.
This is the tip because we have.
That is all for you also?
No, that was the only come. And he was still in P school.
And in fact, for P2, my lord, there is a relaxation. That is my case. That is where my case lies, my lord.
Relaxation was there, but he is
P2,
not.
if I am injured in active government duty, my lord, there's a relaxation. Even though I am P2, I am eligible for promotion.
Now he is P.
What is P2?
P2 is permanent, but then my medical category has been put down from 1 to 2. I'm not absolutely fit, but then it has been scaled down a little.
P2 is in connection with your physical, medical status.
Yes.
Physical.
You are deemed to be P2.
P2.
So P2 doesn't have, there is no impediment.
Normally I cannot, my lord, be considered for promotion. But then if I am injured in active government duty, well, in that case I am.
Why do you doubt your medical board?
First, Lordship, we have not found any medical evidence that.
No,
would-
that is on the findings.
Got it.
But are you doubting the competence?
As for
No, as the employer, you can definitely, you can have the final word. Whether a particular finding is correct or not, that we are not saying, but to differ with a finding of fact, there has to be an application of independent mind to the materials on record.
That was not here,
Oh,
because only we have said that the board has not examined the medical persons who have at that point of time, they were not examined in the court of.
petitioner was not examined.
I
Who
was
examined-
examined. but then-
Petitioner who examined the petitioner,
Or the persons.
the person, medical person
They were not examined where?
at the court of medical, when, well, it's the court of.
Is it required?
Required not to whether injury,
Medical
Because
records
it
are
was
often there.
2005. Where he was
See,
taken place.
you institute a court of inquiry on certain representations made by him. Court of inquiry gives the finding. It has to be concurred or deferred by the commandant. Commandant concurs with the same. Okay. If a finding was in favor of him and still he wants to defer, then giving him some opportunity is okay. But not examining the members of the medical board, is it necessary?
Was the
All I
And-
get is all
And
I
the
get is
nature, and the nature of duties which is
Not.
assigned, writer or clerk. Now you're working as what? Same.
I'm a clerk only.
And your contemporaries?
My lord, they have got the promotion to post of Naib Subedar, warrant officer. Sorry, Naib Subedar.
Naik
I'm a warrant officer. as of now.
now warrant officer will next to
Next
be Naik.
promotional post is Naib.
You have got
Subedar.
a promotion in the meantime.
Not
No, I have not.
The warrant officer is equivalent to the writer.
My lord, there was because of some judgment and the Fifth Pay Commission recommendation, the ranks were raised as different.
Or ranks, well, same post.
My lord.
You are presently warrant officer.
Right.
Now, post of writer redesignated as warrant officer.
From warrant office, I am due to be promoted as Naib Subedar clerk.
Naik Subedar.
Naib Subedar clerk.
How do you spell?
Naib, N-A-I-B,
Naib.
Naib, N-A-I Subedar,
Next post.
S-U-B-E.
Next post.
Next. As far as my lord, the employment part, in active duty is concerned, Lordship knows that the law is well settled otherwise. Lord Denning's judgment, my lord, which has been followed by our Supreme Court also.
Which one?
In Surinder Pandey, in
No, no.
National Insurance Corporation versus Michael has been referred to in Union of India versus Surinder Pandey. Lordship would have a look at para 10.
On the relevancy.
The relevancy is that what
the
is
relevancy
active duty?
factor.
What is active duty is basically anything you are doing as part of your duty.
No, no, what is
active
the
duty.
original judgment? What are relevant factors? They have been watched.
Fact suspected, placing it only for the purpose of my lord, understanding that active duty, see, my being in training should constitute as active duty. I was not on leave or no, I was not doing some personal job at that point in time when the injury had come.
Okay. Okay, anything?
And all I get is my lord,
Para-
to be considered for
Para
promotion.
nine,
my lord.
para 9 of my epic. This is our para 9 of.
You have filed reply also,
Yes,
Mr. Pathak,
My lord,
you have filed reply also.
yes.
I filed a reply.
Para 9.
Good.
What have you stated?
It is subject that with regard to the statement current 1910 of the state, the opponent denies the same and accuses that the petitioner is trying to fit the honorable court by producing the copy of the court of inquiry, which is vague and flawed. The court of inquiry has been held at 24 Assam Rifle to give cover and undue support to the petitioner with regard to his separation in promotion as neither the petitioner had sustained injury at 24 Assam Rifle nor he had initially reported his complaint of the backache there. Hence, the commanded 24 Assam Rifle is not the competent authority to convey the court of inquiry. Also, on perusal of the court of inquiry proceeding, it reveals that the same has been carried out in a mechanical manner, as the essential and eyewitnesses such as instructors, staff that organized PT on 15/9/2005, medical staff that provided him medical treatment, training officer, etc., should have been directed to depose before the court of inquiry. However, simply statement of three witnesses, including the petitioner, have been recorded, and the court of inquiry has been finalized, thereby declaring the disability of the petitioner as attributable to the service with allied intelligence. It is also amply submitted that the petitioner has again stated that the competent authority under respondent number 3, wide order dated
Who is
6
this deponent?
He's in charge of the
It-
legal cell.
legal.
Legal cell. Where does he sit? Shillong.
Shillong.
Where did you suffer the incident?
The incident was covered in
Shillong. Your training was in Shillong.
the training was.
The court of inquiry was held by commandant 24 Assam. Was neither respondent number 3 nor he is serving under him. Commandant number 3 is the workshop. Assam.
No, he has verified as true to his knowledge. That is what we have noticed. 9, paragraph 9 is true as per
Not
knowledge.
gone out of record.
That is why legal person, legal cell, he was obviously not there during the training. Do you have any medical documents here?
No, in fact, that is what was also deliberated in the court on the other day.
No, since they are,
And because my medical examination records are always available with them only. Because periodic medical checkup
what
always happens.
Mr. Roy or the respondents are trying to raise is you will go to the basic, to root of the issue.
Right.
That you did not have any medical issue at all. You did not suffer injury. We have just read that you had complained about some back pain. We cannot just brush aside. They may be right.
Right,
So-
that is why. That is why,
And
my
for
lord,
prima facie, if there are no materials whatsoever before the board, a court of inquiry, to come to a finding of that you had actually suffered, then they may not be held to be totally off the track.
My lord, that is understood. In fact, that is why probably the court earlier had ordered that you look for the whole medical record. And we have submitted that my physical examination periodically takes place in forces. Irrespective of promotion, every year some sort of medical examination takes place. These records are, my lord, basically their record as to my physical condition. Therefore, all records were sought to be looked into, my lord, which now they say is not available.
But this particular training where you had suffered the injury is after 10 years of your,
My lord,
it's not that it's an induction training.
it's not like that.
And how often does this kind of training is
It's almost
prescribed?
routine, my lord.
Huh?
Almost routine, as I
Routine means every year.
every year or
I think
so,
minimum every year at least.
my lord, because to maintain basic fitness, my lord, is required.
Okay. The rejection of the application of the petitioner for his promotion by the Assam Rifles is the subject matter of dispute raised in this petition filed under Article 226 of the Constitution of India. Full stop. Para. The facts projected in this petition are that in the year 1995, the petitioner was enrolled as Lance Nayak / writer in the Assam Rifles and was accordingly posted where?
First posting, my lord, not stated, my lord.
Posted in different, posted and thereafter had served in various places of postings. Full stop. In September 2005, the petitioner, while undergoing the battle physical efficiency test BPET capital held in Shillong, had suffered an injury and was accordingly injury. Full stop. Subsequently, in the year 2014, when the time came for consideration of the promotion of the petitioner, since he was categorized to low medical category, and pursuant to a representation for such consideration, while ordered at 3/5/2018, a court of inquiry was convened to examine the petitioner. Full stop. The aforesaid court of inquiry had accordingly given an opinion on
2008.
on 35, 2008.
30. Page 20 and
Yes,
access.
Recording the aforesaid finding, recording the below mentioned findings, page 25, huh? A, B, C. Page 25, take us. The commander wide order dated 6/6/2018 had also concurred with the aforesaid finding, full stop. The petitioner accordingly submitted further representation dated 12/3/2019 to consider his case for promotion as all his contemporaries were promoted in the meantime. Full stop. However, wide the impugned communication dated 8/11/2019 issued by the Deputy Commandant had rejected the representation of the petitioner on the ground that the injury sustained by the petitioner was during a training and not during active government duty. Full stop. For ready reference, the observations in the impugned order is extracted herein below. Page 30, last organic, paragraph 3. Quote. Para. I have heard Sri B. Pathak, learned counsel for the petitioner, whereas the respondents are represented by Sri S.S. Roy, the learned CGC. Full stop. Para. Sri Pathak, the learned counsel for the petitioner, has submitted that denial of promotion on the grounds cited in the impugned communication dated 8/4/2019 is absolutely unfair and unreasonable. Full stop. He submits that the training in which the petitioner had sustained the injuries were not the induction training, but the routine training which is conducted periodically. And there could be no difference in sustaining injuries during such training and during active government duty. Full stop. He submits that such training is a part of the active government duty, and therefore the grounds of rejection is liable to be interfered with. Full stop. By drawing the attention of this court to the affidavit, to the stand of the respondents put on record by way of affidavit, Sri Pathak, the learned counsel, has submitted that reading of the same would reveal that two grounds of defense have been projected. Full stop. The first ground is that the injury was sustained in a training and not on active government duty. And secondly, the findings of the board of inquiry was a vague one, which is not acceptable. Full stop. It is submitted that neither of the defense is sustainable. Full stop. Para. In support of his submissions, comma, the learned counsel for the petitioner has relied upon the decision of the Honorable Supreme Court in the case of Union of India and another versus Surendra Pandey, reported in 2015, 13 SCC 625. Full stop. The learned specific reference has been made to paragraph 10, which is extracted herein below. Then 10, 11, and 12, which is extracted herein below. Full stop. The learned counsel further informs this court that there has been redesignation of the post concerned, and presently the name of the post held by the petitioner is warrant officer, and the next promotional post is Naib Subedar, NAIB, before Bombay, Subedar. Full stop. Para. 3. Roy, the learned CGC, on the other hand, has submitted that the decision of the Deputy Commandant as communicated wide letter dated 8/4/2019 is not liable to be interfered with. Full stop. By referring to the affidavit in opposition filed on 19/8/2020, comma, the learned CGC has submitted that adequate reasons have been pleaded to justify the impugned action. Full stop. It is submitted that there is a distinction between injuries sustained in a training period and those sustained in active government duty, and the consequence of sustaining such injuries in the two cases cannot be equated. Full stop. Emphasis has also been laid by the learned CGC on the procedure adopted, on doubting the procedure adopted by the Court of Inquiry, which had culminated in the opinion and also the concurrence order dated 6/6/2018. Full stop. he submits that the findings are vague and cannot be relied upon, and the aspect of the injury sustained during the training period has been totally overlooked. Full stop. Para. The rival contentions have been duly considered, and the materials placed before this court have been carefully reduced. Full stop. To examine the case of the petitioner vis-a-vis the defense of the respondents, comma, it would be necessary to look into the grounds on which the impugned order has been sought to be defended by the respondents. Full stop. There are two grounds which are discernible from the affidavit in opposition filed on 19/8/2020. Full stop. The first ground is a distinction which is sought to be carved out between active government duty and the training period. Full stop. The second ground is questioning the findings of the Court of Inquiry. Full stop. Para. Let us examine the second ground. First, full stop. The objection is that the findings are vague and not acceptable. Full stop. The materials on record would show that an order was issued on 3/5/2018 by the competent authority convening a court of inquiry which was also constituted. Full stop. The aforesaid court of inquiry in its sitting had examined three numbers of witnesses, three or four, three numbers of witnesses. And after examination of the materials on record, had come to a finding and thereafter had given the opinion which has already been extracted above. Full stop. The findings and the opinion cannot be said to be vague in any manner or have been given without examination of the materials on record. Full stop. The competence of the convening, the legality of the convening order or the competence of the court of inquiry have not been questioned. Full stop. In any case, comma, it would be wholly unreasonable for the respondents to question the findings of the court of a court of inquiry which was constituted by the respondents themselves. Full stop. Though in a given case, the findings may not be concurred with, comma, the present case does not contain any such circumstance for which the findings can be treated to be vague or unacceptable. Full stop. As regards the first stand, whereby a distinction has been sought to be carved out regarding injuries suffered in active government duty and those suffered in a training period, comma, it is not in dispute that the aforesaid training period was not an induction training, but a routine training which is required to be undergone by every employee oblique officer under the respondent organization. Full stop. The petitioner was appointed in 1995 and the training and the injuries were suffered in the training held in the year 2005, for which the petitioner was categorized to low medical category. Full stop. This court has also been informed that the petitioner's appointment was as Lance Nayak oblique writer, which is presently redesignated as warrant officer. Full stop. It is also not in dispute. The petition, it is also, this court has also been informed that your what P2 you had said?
My lord, this relaxation available for P2 is at the next 12.
That there is a relaxation meant for P2 officers.
My lord.
And the petitioner, you are entitled.
My lord, if I am injured in active government.
And if it is construed that the petitioner was injured, and if it is construed that the injury suffered by the petitioner is during active government service, comma, he would be entitled to such relaxation. Full stop. Para. This court is of the opinion, finds force in the contention of the learned counsel for the petitioner, who by relying upon the case of Surendra Pandey, Supra, has submitted that such distinction of injuries suffered in a training and those suffered in active government service is not sustainable. Full stop. Para. In view of the above, comma, this court is of the opinion that a case for interference is made out. Full stop. Accordingly, comma, it is directed that the case of the petitioner for promotion to the next higher post of Naib Subedar is required to be considered on its own merits, along with other eligible candidates. Full stop. The aforesaid consideration be made in the next promotional exercise as and when conducted. Repetition accordingly stands allowed to the extent indicated above. To the extent accordingly stands allowed. No vote. Others, we may not have time. We already overshot some meeting. Okay, is there any matter where interim order is still today? Any matter interim order needs to be extended? No. Others, court master will give suitable dates.